And pray for listing this
Listing.
Yesterday's metal mailer. Yesterday's metal mailer. I have filed reply as well as an IE mailer for striking of those particular lines. Taken up on Monday mailer.
Otherwise, what is your urgency?
I have been reverted to my
Understand, but that was quite a reasoned order. It's not that without anything somebody is reverted back arbitrarily.
30 years of service as official mailer.
30 years doesn't. Thing is whether you are entitled to the promoted post or not. I think they have passed quite a reasoned order. In fact, we have gone through the order yesterday.
Yes, my lord. But even Lordship will the record, my lord. Lordship will.
So we'll take it up after vacation.
In the meantime, will be.
Definitely, if you are not entitled to hold a promoted post, I think, Mr. Chisti, was that order passed after hearing the petitioner?
Yes, I have confirmed because after hearing both the petitioner, Jitendra and Amol Bora.
There is a circular, based on which my lord he was upgraded. That circular was not put to challenge before any court of law, my lord. On the basis of that
So
circular.
we'll hear you.
Yes, Lord.
That is why, my lord,
This requires a hearing. It's not that immediately
Yes, exactly.
something grave arbitrary act had been committed. Then we would have definitely looked into it. Suppose without any rhyme or reason, one man is demoted. You can expect the very first day he'll get a stay. But this is not the case. In fact, Mr. Saikia, having a feeling that it may be a case of an arbitrary demotion, we allowed you unlisted yesterday. But after reading the order, we find that it is not an arbitrary order. It's a reasoned order.
my lord, that in respect of the private petitioner hearing, my lord, and other.
See, think about the other one. If another man is entitled to promotion, it was wrongly given to this petitioner. He had processed his matter through writ petitions, through a hearing through the authorities. After hearing you, now he is getting back his legal right.
My lord, he
Why should his legal right also be
is
stayed?
claiming seniority over me, my lord, not that post, my lord.
I understand,
He's
whatever it
claiming
is.
Seniority over me.
So whosoever is
Because
senior
he was also
will be
entered,
entitled.
my lord.
Sorry, we don't find urgency, Mr. Saikia. We'll take it up after vacation. And your conduct also we didn't like.
My lord, that-
So equity also is not in your favor.
my lord, that's a copy paste of the writ appeal, my lord. That is why, my lord.
Whatever it is. Whatever it is, it's a little slanderous. Another judgment of another court, you are simply alleging allegation against the judge and the court.
That is.
So why should you accept this kind of a behavior? Sorry,
Not
no?
been done.
Reject it. Yes, next one.
Lordship, my please, Lordship,
No
Lordship, I
problem.
went to mention an item for listing Lordship.
What is the urgency?
Lordship, the petitioner is not given opportunity to participate in the selection process of principal Lordship. The Lordship, that process has been initiated. So Lordship,
Why he is not given? Why do you say he is not given the opportunity?
Lordship, actually exactly the facts of the matter.
Hey,
Completely aware, Lordship.
no. Have you applied?
Lordship,
Did you apply or you did not apply? First, find out that. If you have applied, we can ask them to consider your application. But if you have not applied, we don't know. We'll have to-
Lordship, perhaps he has applied, Lordship, I'm not.
Then
completely-
on a perhaps we cannot pass orders.
Lordship, I.
Find out
seek-
first.
Seek your apology, Lordship. Lordship, kindly list the matter.
See, we are wasting time. It's a judicial time.
Lordship. May I mention another matter, Lordship? This is,
What is the urgency?
Lordship, this is a matter.
See,
of-
we are not rejecting your request. Only thing, what is the urgency? So that it has to be taken today or by Monday. Because we have practically only 2 days to
Yes.
take up matters.
Lordship, this matter may be taken up on Monday, Lordship.
Why?
Lordship, the second matter is pertaining to education volunteers, Lordship. So these people have been, Lordship, this program has been abolished and they are suffering a lot, Lordship.
But there is not an urgency. We can deal with the matter immediately after the vacation also. If it is an illegality, we'll definitely restore it back. Don't worry.
Lordship, similarly situated, some other education volunteers. are
They,
also-
they came on time. You are a little late. You have to bear with the system.
Lordship, okay,
Yes, next item, please.
Lordship.
After vacation, please give it.
Okay, Lordship,
I have to also file a case yesterday, my lord.
What is the urgency?
Urgency, my lord, this principal of Guwahati College has removed his HOD of botany with some stigmatic remarks, but university has confirmed that this fact is not correct. So he has not-
Immediately after the vacation, we'll take it up.
but some promotion avenue is there at this November, my lord. So
November, we'll take it up in November itself. Don't worry.
that is.
And you can be rest assured, if you have made a good case, you'll get interim orders. Even retrospectively, we'll restore your situation. Don't worry.
My lord,
Yes, next item.
May I please, your lordship, I beg to mention item number 12, 13, 14 and 15, lordship.
12, 13, 14, 15.
Matter may be kindly taken up after figures.
Yes, turn on to likhbo, adjournment. Yes, ma'am. Listing or adjournment?
Please, for urgent listing, my lord. The petition is student, my lord.
What does the word
Exam-
urgent mean?
They are student and exam may be held on December, my lord. They are already restricted, my lord.
Sorry,
So, and already students are restricted, 5 student, my lord. Petition.
what happened to 5 students?
Well, this is a ragging case, my lord. Already restricted from their
So
university.
they were.
Exam may be held on
Okay.
November.
Yes,
I beg to mention item 30, lordship, 30.
adjournment.
No, lordship would do it and maybe allow.
Let the item be called, we'll pass the order. Let the item be called. Yes, ma'am.
Your lordship, I beg to mention for the listing of a WPC matter.
Oh, what is the urgency?
Urgency, it is a case for regularization of job. In
Regularization has no urgency. We'll take up immediately after vacation. Yes, next anyone.
Person will retire in a month or two,
Month of?
from the job. Just not been regularized yet.
When will he retire?
In a month or two, your lordship.
Sorry,
In a month or two.
what
maybe
is it
Nov-
mean by month or two? What is the
November.
exact date of retirement?
It was November, I.
We'll take up in November. November first we can take it up. And why do people come at us so late at times? You could have come many years earlier. If that is the case.
Item 1 for motion.
Yes, Mr. Hook.
May please, lordship. No, last few occasion, my lord, the respondent reacted to file their affidavit.
Prayers, just a matter again. 2 weeks time granted last opportunity to file.
Some instruction has been some.
No, last opportunity is over long time back.
Some.
So we take it up without the affidavit. Yes, you will, please.
Yeah, my lord.
It's a motion.
My lord,
Please, argue.
there were petitioner had my lord, passed in the my lord, state qualification, my lord, state-
Why notice not issued for 4 years?
My lord, petitioner has submitted an application, my lord. What happened, my lord? They are-
No, no. First, give the answer. Why notice was not issued for the last 4 years? It's a pending in motion, matter of 2019. Why?
My lord, initially, my lord, some different sets of advocates were appearing, my lord.
But
They are-
that is not a
No,
reason.
my lord, hopefully, my lord, instruction. In fact, my lord, on interim order was also passed, my lord.
I know you are enjoying the interim order, so I don't bother the matter to be taken up.
My lord,
Let me do it for the next few years.
No, my lord, actually, my lord, I am passing the matter regularly.
Sorry,
I am passing the matter regularly now, my lord, after being.
but why you have not gone for a notice? We don't
My
understand.
lord, basic thing on that, in the year 2017, my lord,
Just
they are-
a minute. What kind of interim order is there?
my lord, one post of.
Hmm. See, you were held back one post. And the only order is, Mr. Kaushik, you are also department to be equally blamed for this interim order. First order is 8/11/2019, list the matter and so to take instruction. Your standing counsel must have said, I want instruction. So court says keep one post vacant. For the last 4 years, no instruction, interim order is continuing. So you make the interim order absolute. If you are not interested,
One instruction which has been sent. by-
Mr.
Hello.
Kaushik, if you are not interested to not to have the interim order for the last 4 years by not providing instruction, who can help you?
Your lordship takes up at 2 o'clock, my lord.
No, just give the answer. Who can help you?
Yes, it's true one. I have some instruction.
And
has
there
been
is,
sent, my lord,
it's
I'm
not an
unable-
interim order on merit.
Yes, yes. it
It's
is
an
on
interim
convenience.
order only on the submission of the state council that I want to obtain instruction.
Accommodation. Like, my lord, one instruction which has been sent, my lord, I am unable to download it. Doctor will take about 2, my lord. I'll ask them to resend it.
And what is your case? Why one post should be vacant?
My lord,
What legal right of the petitioner?
my lord, petitioner had qualified in the state, my lord, Royal Primary School, my lord, held in the year 2012 as well as 14, my lord.
Hmm,
Both in the preferred language of Bengali medium. Bengali medium.
sorry,
Bengali medium, my lord.
he passed it in Bengali medium. Okay. Fine. So,
Thereafter, my lord, in the year 2017, my lord, the department has issued an advertisement, my lord, for absorbing the teachers on the state qualified teacher who were qualified in the TET examination. Thereafter, in the year 2017, my lord, they had scheduled a date, my lord, for my lord, document verification, my lord. Unfortunately, my lord, during that period, my lord, petitioner was appearing in the BEd examination and under the God University.
no, there is nothing called unfortunate.
My lord, now, since the disputed,
We want to know what legal right you have
now,
and which right has been violated.
thereafter, my lord,
That is why the courts are here.
since, my lord, the date.
Because if courts are there to take care of the fortune of the peoples, maybe we would have had a different power. Yes,
My-
Mr. Nair.
Now, my lord.
We have the, do we have the power to give fortune to the people? We don't have that power.
My lord,
Only thing we can look, what legal right you have. He said he is unfortunate. Well, we don't have the power to give you fortune.
now, my lord, thereafter, my lord, what happened, my lord, since the date which was fixed for, my lord, document verification, my lord.
No, but you want one post in the advertisement of 2019 to be vacant.
Yes,
Why?
43. In the 2019, my lord, the post which were advertised.
No, no, why you want the post to be vacant? You go and participate. If you get selected, you will be appointed.
My lord, in the year 2017, my lord, after the 2017 document verification, the list which was published, my lord, there are some candidates who were selected who got the lower mark than the petitioner, my lord.
You challenge that.
That is not correct. My
If
lord,
you have participated and somebody below the petitioner was selected, you challenge it. We'll look into it.
yes,
Definitely.
can-
That's a law.
Now, my lord,
Suppose you participate in a selection, you find on merit somebody lower than you is selected. Immediately you challenge that.
now, my lord, the one thing, my lord,
No, it appears this is a little frivolous petition.
my lord,
Therefore, we are asking you these questions. And till now, I have not noticed any legal right of the petitioner which is violated. The observation that we are not here to give fortune has some relevance, which a purpose we stated it.
I appreciate that. Only thing, my lord, petitioner had submitted several conditions, as well as,
Maybe
my lord.
what do you want? What do you want? And why?
Based on his state qualification. he wants to-
Declaring the inaction order to appoint the petitioner having. This is a negative declaration.
Yes.
There cannot be any declaration that declaring inaction order to appoint. What legal obligation they have to appoint you? In other words, back to the petitioner again, what legal right you have to be appointed?
My lord, at least,
In this writ petition is instituted with a prayer as to why a writ in the nature of mandamus shall not be issued, declaring inaction on the part of the state respondents to appoint the petitioner in spite of having qualification of TET. Qualification of TET is apparently only an enabling qualification to participate in a selection process. And that by itself is not an assurance of an appointment. The petitioner to clearly state as to what legal right of the petitioner has to be appointed by participating in a selection process pursuant to any advertisement. And secondly, what legal duty the state respondents have to appoint the petitioner. This Tom so. Interim order earlier is not continued any further.
Sorry.
Item 2 and 3.
Mr. Kaushik, why are you allowing these frivolous petitions to continue for 4 years? And you must have disturbed one selected candidate. one selected candidate of 19 must have been deprived of his appointment because of all this. Don't you feel bad for that man? One who struggled in his education for the entire career, participates, is to be selected. And this kind of a frivolous litigation, one keep one post vacant, is deprived. And that too for 4 years, instruction. Instruction, what instruction you wanted to bring? On the first day, the council said, I'll bring instruction. Court also didn't ask you to bring any instruction. What instruction you intended to bring? Mhm.
Because apparently in 2019.
Nothing is
advertisement,
there.
He did not even participate.
See, when do you bring instruction? When the court wants some factual
Actually.
situation to be told, to be placed before the court. Only then you will,
And apparently.
court never asked you to, for any information. It's listed in motion, one council standing up, I'll bring instruction. Very well. And for 4 years, you could not bring instruction because you don't know what instruction to bring. What can you bring? Today, suppose I say, place that document or place this record or place this information,
Then we can.
you know what to bring. But without any rhyme and reason, is to say, I'll bring instruction, and you. What you're supposed to do after that?
The post advertised in 2019.
Hmm.
That in that advertisement, he did not even participate.
Understand. So don't you think because of our interim
Yes.
order, one
It was-
selected
it
man
was-
was deprived?
It was our fault.
In as much as the interim order is discontinued, the respondents to also look into as to who would have been the selected candidate who was deprived because of the interim order of keeping one post vacant, pursuant to the advertisement of 2019. Date to Sailava, huh? If you have a legal right, you have it in 2017, will determine your right.
My lord.
Even nothing of 2019. And if somebody is illegally appointed, you are deprived. We'll go into that aspect.
2 and 3.
2 and 3 years, Mr. Progress.
My lord,
Which legal right has been violated? Same. With reference to submission of Mr. Progress. That the probability of being promoted had been reduced because of subsequently more names.
the instruction from my client to
Not to press it.
Not
I used a better instruction, I think. B. Progress to learn Constitution states that there is an instruction from the petitioners not to pursue this petition any further. In view of such submission, writ petitions, both the writ petitions stands closed, cover order Mariva. However, liberty granted to approach again if so advised for approaching the court in any appropriate manner. Not in this manner or nothing.
Not my preparing for access.
Mr. P. Naik for the SSC, Mr. Assembly 60, elementary education, secondary education department.
Item 4.
4, yes, Mr. Talukdar.
My lord,
Payable and council says the information received reference to order is incomplete. 8, 9. You are provincialized. By which order?
What is even pursuant to the order of this honorable court, there was a determination by the Director of Elementary Education. And my lord, determination was in my favor that my service is, my lord, I am entitled to.
You were
provincial.
entitled provincialized.
Now, the consequential, my lord, appointment order is not.
I know, where is that determination?
Yes, my lord, your lordship will come. That. It starts, my lord, the type copy starts from page 24, my lord. And my lord, the operative part is at page 29, my lord. The order is there, my lord, down below. In view of the above facts and materials on
In
record.
view of the above facts and material on record, is seen that the petitioner Abul Hassan is liable to get all benefits of his services as ATO and may be considered for provincial national service as per act of recommended. What more?
Yes.
We are disposing it of. The who will pass the order?
My lord,
Director has already passed. Now who will pass?
my lord, he will issue the appointment order.
Heard Mr. S.K. Talunjar, Land Council for the petitioner, also heard
If you can find the respondent,
Mr. A. Phukan for the respondent, elementary education.
elementary.
Elementary Education Department. The petitioner Abul Hussain was appointed as the second additional assistant teacher in the Kesar Bhita MEM on 18/5/1998. Where is the order dated 16/6? State some 16/6 order. Hmm.
My lord, there is an order at page 18, my lord.
No, if you come to page 29,
My lord.
I
29.
think the fifth line from below, a wide order dated 16/6, it has been stated. Where is that order?
My lord, page number, my lord, I could not get it. My lord,
29,
29.
last 5 lines. There is a reference, wide order dated 16/6/2017. He is liable to get all the benefit. Where is that order?
That order, my lord, is not part of the records perhaps, my lord.
Perhaps that goes in your favor possibly.
Yes, my lord. Yes.
Now, if you can look at that order, maybe your rights will be more crystallized if you can record that.
In fact, my lord, this particular order has been passed by the director pursuant to the direction of this honorable court.
I understand, but where is the order?
That order, my lord.
Once I get hold of that order
Correct,
and
correct.
quote that order,
Correct, my
I think your order in your favor will be
lord. Correct.
a better and more stronger order. Do you have it?
I don't have it.
Can you get it?
Well, I have to find it out. But since there is a determination, lordship can say my lord, that consequential order may be passed.
No, that's a court order.
Correct.
No, because here your right has been determined by somebody. I don't know who. He is liable to get order, may be considered for provincialization. Hmm.
There is an order of your lordship at page 14. Your lordship had passed that order.
Did Abdul Akhir file any writ petition?
Uh,
Is it pending somewhere?
Abdul Akhir has filed one.
Is there any stay order?
My lord, no stay order.
Hmm.
I have stated in this petition.
No, because why you say
Yes.
everything is determined in your favor and the provincialization order of Abdul Akhir is cancelled.
Cancel. Yes,
So somebody cancelled, you are entitled.
yes. Lordship will see at page.
Maybe the other person has filed a writ petition, because of that they are not issuing this
14. No,
order.
if your lordship comes to page 14, it's your lordship's order, page 14.
Maybe my order will not make it
No, what I'm trying-
more special for it.
No, what I'm trying to say, because your lordship has indicated that Abdul Akhir, he belongs to a different stream. So
Understand?
therefore, he has no contest with me.
Possibly they are not issuing the order because of the
No,
pendency
that
of
is
the.
not the reason, because the writ petition has come later on. I have stated in para 7, my lord. If your lordship comes to para 7, this
Yes,
is the
Mr. Phukan,
para 10.
tell us the reason why you are not, we'll take up after some time, ask the director. We'll take up today itself, ask the director why he is not issuing it.
I'll get this.
Because in spite of everything determined in his favor, why order is not there?
I'll get the answer.
I think that'll be better if we know the reason.
Correct.
5 to 7.
5 to 7.
May I please, Lordship? Lordship, I'm appearing on behalf of A. Suma. Lordship, please place on another portal. Can it be taken up at 2, Lordship?
Let it be on any other day, other than today.
Yes, MS, your name,
Lordship, Monday,
your name.
K. Borpujari.
A. Borpujari states that who is in another court? That Mr. A. Soma is in another court and therefore the matter be deferred for the time being. And on the other hand, Mr. UK Nair and Senior Counsel for the respondents state that he is otherwise ready to take up the matter at present, but later on there will be inconvenience and therefore another date be fixed, considering both the prayers list on whenever. it is there.
Monday, 16.
Item 8.
You take up whatever you get. Yes, sir. The pharmacy, huh?
Lordship. At this stage, Lordship, I pray that a notice may be issued, Lordship, because my NOC application was rejected, Lordship, page 52. And other restrictions are.
Notice. Yes, ma'am, we issue notice. Heard Mr. K. Mojumdar and counsel for the petitioner, also heard MS D. Bora for counsel for the respondents in the Health and Family Welfare Department of the Government of Assam, and MS A. Gayan for the Pharmacy Council of India. Notice 6 weeks, extra copies 3 days, list after 6 weeks.
Lordship, I pray, Lordship, that this matter may come along with WPC number 1998 of 2000.
Same issue.
Lordship, same issue subsequently that order was. So suppose I have to challenge that.
On the prayer of Mr. K. Mojumdar, and list along with WBC so and so. But in the event it is found that the other writ petition is unconnected with the present petition,
Connected.
the petition should be separated.
Item 9.
Can you pass over the for time being Lord?
10.
Yes, but to delay লিখিবা নিদিলে নিলিখিবা. Don't write if they don't give. বিচাৰি ফুৰা দৰকাৰ নাই.
Your Lordship,
No.
kindly
Yes, madam.
kindly pass over the matter for time being. My senior counsel.
Item 11.
Yes, madam.
Your Lordship, my lord, this matter relates to compassionate appointment, my lord. Here records were called for, my lord.
The records were called for. Deputy Commissioner to file affidavit why recommendation made without providing any reason. Yes, Mr. Pegu,
We are yet to receive.
how can you examine this matter if you don't indicate anything? Unless some material is given, we cannot examine whether it's a right order or a wrong order. One time. Adjourn to enable the Deputy Commissioner to produce the records as indicated in the order of 4/10/2023 list on Swins.
Item 16.
16. Sorry,
Instruction is available, madam. Next.
As per
she's trying to say something. Yes, madam, what you say?
Instruction is awaited, madam. On the last occasion.
Instruction awaited.
13 November.
as per my lord, what happened during. They issued the impugn order. There are 3 inquiry reports already.
We'll hear him.
10 time ago.
Today we'll hear him. Yes,
But
Mr.
I-
Purva.
I'm the, my lord, the senior most teacher. is
No,
it?
where is the impugn order?
Page 51 is the impugn order, my lord,
51.
whereby they have
Partial
Well,
modification is
yes.
hereby allowed. Yes. Heard Mr. B. Purokastle and counsel for the petitioner also heard you are appearing, madam. As to hear for the respondents in the Elementary Education Department, Government of Assam. But you have not made this Nandini Mukherjee,
she's the block officer in charge, my lord. She's block officer.
but still she may have some personal interest.
Official capacity has been given, madam. Block officer.
Maybe.
Petitioner is the party.
Now, who is this petitioner?
Petitioner is the headmaster, senior most teacher of the school, madam.
What legal right you have?
I'm the senior most teacher. I was holding the post as the.
No, you are not holding.
Yes,
Mukherjee comes in place of Sinha.
There,
So petitioner's ouster must have taken earlier when Sinha was made the member.
page 42 is the
So
order.
this is not a new event.
Second event, my lord.
Maybe we'll issue notice.
My lord,
I heard Mr. This doesn't call for an interim order, Mr. Purvai.
What happened, my lord?
Initially, I thought that you were ousted and another person, junior, had been brought in. We intended to pass an interim order, but this is not so. That is different.
Let me tell you, my lord, what happened, pursuant to the earlier order, we have put to challenge in this honorable court, my lord, and this honorable court, my lord, directed that as per order dated 17/8/2022. I was there, as I was holding the charge, my lord.
Which page is
Page
that
50,
order?
page 50, my lord. Here, last order. my lord. I was continuing.
That is 17/8/2022
Yes.
is your,
Yes. That is at page 42, my lord.
this writ petition is pending.
Yes, sir.
We'll list it together.
Yes.
List along with WPC and then take up both together and pass the order. List along with WPC 2210/2023. It is noticed that by the order dated 28/4/2023 in WBC 2210/2023, in paragraph 10, it had been provided that since the order dated 17/8/2022 had not been recalled or superseded by the in charge DO Kachar Silchar, in the order impugned therein dated 27/3/2023, the same shall remain in force. In other words, we have to read that the order dated 17/8/2022 is still in force. By the, where is the order dated 17/8/2022?
42, my lord.
42. By the order dated (17/8/2022), the writ petitioner Mizarul Islam Loskor was allowed to act as the in charge headmaster cum member secretary of Janata ME School Managing Committee. By the order impugned in this writ petition of the in charge district elementary education officer, comma, in partial modification of the order dated 27/3/2023, which was referred by in para 10 of the order dated Agor writ petition order dated so and so WBC so and so. Nandini Mukherjee BEO Sonai is allowed to act as the member secretary. It appears that the conduct of the in charge district elementary education officer can also be viewed to be contemptuous in nature, inasmuch as when there is an order of the court that the earlier order of 17/8/2022 would remain in force, in spite of the order dated 27/3/2023, the in charge DEO now supersedes the order dated 27/3/2023 and appoints another BEO, Nandini Mukherjee, to be the member. The order dated 14/9/2023 shall remain stayed until further orders, and the in charge district elementary education officer is directed to comply with the requirements of para 10 of the order dated so and so in WBC so and so. Further, the in charge director to also show cause as to why appropriate contempt proceedings should not be issued against him. Issue notice returnable 6 weeks, extra copies 3 days. List along with WBC so and so.
17.
Return 4 weeks করে থৈ দিয়া। এটা fixed date দি থৈ দিয়া। After 4 weeks. Yes, ma'am.
May I plead, your lordship?
They were pertaining to.
Yes, madam, we have received the record.
The admit card is 15 years, certificate is 16
No,
years.
that's why my the certificate is correct.
This
As per record,
Certificate
my lord, we have tell it.
4 weeks.
Admit card is my lord, is overrating here.
Admit card is wrong.
Admit card is here is overrating.
Page number.
Page number 25.
This November.
My lord, this is original.
Just.
আমি চাও। ঠিক আছে, আমি চাও।
There is no overwriting.
My I collect the original one.
But there is no overwriting also. If it is wrong, we don't know, but there is no, at least there is no overwriting.
Here, my lord, the photocopy.
No,
No, anyhow, my lord.
No, sorry, we are not convinced with the overwriting.
Anyhow, actually, okay, there's no, maybe my lord, original, but here is, seems to be overwriting in a photocopy, my lord. Admit card,
No,
my lord,
Mr. Chutia, I don't know what document you are holding.
we are.
Page
holding the-
25 before the court, there is no overwriting.
Yes, so.
they have collected.
My lord, this TR is a document.
So now what is your case? Why
Yeah.
two different dates
Yes,
of
yes.
date in two different
lord,
documents by the board?
1996. 1996, in earlier occasion, admit card is not printed at Seva office. Only we have sent it, these are filling up by the institution, headmaster of the school, they fill up. And we are sending, and according to their ballot statements, we are recorded their age. These are ballot serial number 17. 17.
As per record, they have done mistaken certificate. It was their fault.
But how can you take advantage of their fault? It's clear. Your date of birth is 1650.
64.
Please, you can take a look at this.
And during that period, the principal, headmaster, they facilitated.
That was a very,
Admit card is only for admission. to
I
the-
understand, but still, that was a very undesirable delegation of power.
At that moment.
If you are issuing admit card, you issue it.
At that moment,
Why do you again give it to another person to do it?
since 96, my lord,
Understand?
that has been printed.
That is not a very desirable practice to have been followed. Say, tomorrow if I start the process, I'll not write the judgment. I'll sign and put it before Mr. Chutia, you write it. Will it be
Maybe,
accepted?
maybe. That is.
Same thing the board had done.
Yes, yes.
We are signing everything admit card, you fill it up.
There's a very valuable records in our office, my lord. All officers, those who are passed and under.
Yes,
Seva,
madam, we have noticed it. What do you do? Issue notice? We are not dismissing your case.
So we'll file a very better.
Your person is going to be returning 30.
But how can we change it? That was a mistake, they say, and mistake not of the Seva, mistake by the school. Because at that time, school is to issue that, that's what he's saying. And according to them, they issued a certificate, shows the correct age. But MS.M. Das, President Council Petitioner, Mr. T.C. Chutia for the respondents in the Seva, and Mr. S.M. Chisti, the Council for the Secondary Education Department, going to issue notice returnable 6 weeks, extra copies 3 days, list after 6 weeks.
Our
The petitioner raises the issue that there is a discrepancy in the age depicted, the age of the petitioner depicted in the admit card and the certificate issued by the respondent Seva. To the extent that the admit card shows the age to be 15 years, 5 months, 0 days as on 1/3/1980, whereas the certificate shows the age to be 16 years, 5 months, 0 days as on 1/3/1980. Mr. T.C. Chotial and then counsel for the Seva has produced the records in original, which shows the age of the petitioner to be 16 years, 5 months, 0 days as on 1/3/1980. List after 6 weeks.
Complete.
Item 18,
Mr. Mannan.
Wait, please, your lordship. This matter, your lordship, I am challenging the termination of services of the petitioner without your lordship following the procedure of the
Where is the termination?
termination, your lordship will find at page. It's a termination of all the petitioners together, your lordship. As well as some other persons together, that your lordship will find at the page number 77.
Just a minute.
They were
Yeah, just a minute. Yes, Mr. B. Chaudhary. Read 75 and 77 together. Pages. $75, it is clear. He is placed under suspension pending trial of proceeding under discipline and appeal rule. Now read 77. You based on 2 inquiry reports and terminate.
Yes,
It is your own case that you will draw up a proceeding, draw it up.
they have not drawn you.
Without drawing, page 75 and 77 cannot coexist together.
Lordship, let me have.
We stay timing. We give you the liberty to draw proceeding if you want. Otherwise, it will be unfair because first you place under suspension under the 64 rules, saying you are suspended pending royal of proceeding. After some time, you terminate them based on 2 inquiry reports. So if you intended to draw proceeding, these 2 inquiry reports must be provided to them. You should conduct a further proceeding under the discipline and appeal rules.
Rule 9.
Rule 9 inquiry.
Rule 9. has
And
not
these
been-
2 inquiry does not appear to be rule 9. It's kind of a preliminary inquiry.
Lordship, maybe the report by the RMSA,
No, that will not help you.
maybe they have
E-
participated in that inquiry. Lordship.
Even if it is so, it will not help you. Because that will be a preliminary inquiry and not the inquiry under rule 9.
And secondly, Lordship, this is an order almost 11 months back.
Doesn't matter. If it is without jurisdiction, it has to go.
Lordship,
Passage of time will not bring in balance of
No, we have
convenience
filed an appeal also. In the
to,
meantime.
to sustain something without jurisdiction. This is an order without jurisdiction. We are not on merit. Merit, he may be the most undesirable man to remain in service. Possible. So to protect your interest, we give you liberty. If you want, you can initiate the proceeding, complete it. Without prejudice to this order and the interim order to be court, you can still draw up a proceeding and complete it and terminate them as per law. In the meantime, they'll be under suspension.
Yes.
Because suspension order is still valid.
In fact, your lordship,
Heard, Mr.
one more thing. Earlier, during the suspension period, we
Mr.
filed a-
Rangan, we don't intend to give something more benefit than what we have
not saying
indicated.
that, because earlier.
Because that will again be injustice against them if I give you more.
I'm not asking for. more.
I'm just trying to balance the two.
Only pointing out that earlier I came before this honorable court challenging the suspension. And that time it was withdrawn because of the final order was passed. So there, in fact.
Okay, you can challenge it, but
No, that I'm not challenging it. The only thing.
but
is
that
sus-
challenge will not hold good.
subsistence allowance were not paid at that time.
That will get it.
That much, that's all.
It will be as per law. Heard Mr. Y.S. Manan, and counsel for the petitioner, also heard Mr. B. Chaudhary, learned standing counsel for the authorities under the BTC. And MS S. Thutia, learned counsel for the Elementary and Secondary Education Department of the Government of Assam. The petitioner's hearing having the qualification of master's degree and B.Ed as well as TET. Where is the appointment?
Appointment, your lordship,
Were appointed,
all the appointment letters are
I think annexure are
series.
6 series. Page number.
From page 64 onward.
Were appointed as assistant teacher arts in the Boro medium in the scale of pay of PB 14000 to rupees 60,500 and grade pay of 8700 plus other allowances and posted at different higher secondary high schools, at different schools under the BTC. The petitioner also refers to certain advertisement and selection procedure that were initiated by the authorities in the BTC where they had participated, and upon being successful in their selection process, they were appointed. The Director of Education BTC, by an order dated 6/10/2021, had placed how many PT? All of them. All of them are here.
Not all.
Are
Your Lordship,
36
only 12
before
are
us.
here. 12 are here.
Had they placed the petitioners under suspension along with some other teachers. With immediate effect, inasmuch as the petitioners were arrested by the police in connection with police case number 10/2021. Which police station?
This is under the.
There must be some police station.
Next.
Hmm.
Next.
Under so-and-so police station 10/21, under 120B of the Indian Penal Code, read with 420, 467, 468, so 471. Inasmuch as that death certificates that they had relied upon were found to be fake. The order dated 6/10/2021 is extracted as below. 75. A reading of the aforeextracted order of the Director of Education BTC makes it discernible that the petitioners were placed under suspension pending drawal of departmental proceeding under the Assam Services Discipline and Appeal Rules 1964. In other words, we have to understand that the suspension was under Rule 6 of the Rules of 1964. Please, Mr. Mannan.
Yes.
Relax. Because one utterance from you disturbs my entire flow. Please, let me complete.
Yes.
Something to be added, you can indicate,
CID.
but
please.
not now.
Yes.
Not in the middle. Igolo. 4, and the contemplated departmental proceeding, which is stated to be pending drawal of departmental proceeding, would have been a proceeding under Rule 9 of the Rules of 1964. In the aforesaid circumstance, the order impugned dated 26/12/2022 had been passed by the Director of Education BTC, by which, based upon a letter of the BTC dated 21/12/2022, report of the Mission Director RMSA dated 1/11/2021, inquiry report of the Inspector of School dated 22/7/2022, and another inquiry report dated 13/7/2022, the services of the petitioners who were earlier placed under suspension were terminated to be with ab initio effect, inasmuch as fake TET certificates were relied upon. All the materials referred in the order of termination dated 26/12/2022, as indicated above, prima facie appears more to be in the nature of preliminary inquiry or preliminary material that the authorities had in order to arrive at a conclusion that the petitioners had relied upon certain fake TET certificates to enter service. As the petitioners were suspended under Rule 6 of the rules of 1964, with a further provision that a suspension is pending drawal of the departmental proceeding, which again would have to be a proceeding under Rule 9, we have to understand that the two inquiry reports as well as the other materials referred in the order of 26/12/2022 is not an inquiry report contemplated and provided under Rule 9 of the rules of 1964. In other words, prima facie, it appears that the order of termination was made without adhering to the requirements of Rule 9 of the rules of 1964, although it is the stated case of the respondent themselves, while placing the petitioners under suspension, that it is a suspension pending drawal of a departmental proceeding. Full stop. From such point of view, it appears that there is a procedural aberration by the respondent Director of Education BTC while terminating the services of the petitioner. But however, we also noticed that the purported reason for terminating the services of the petitioner is that they had relied upon certain fake TET certificates, which itself, if established by following the due procedural law, would render the appointment of the petitioners void ab initio. But however serious an allegation may be, the same cannot bestow the authorities with their power to dispense with the procedural requirements of law in order to effect a termination. We also take a note that the petitioners were earlier placed under suspension by an order dated 6/10/2021, meaning thereby that in view of the allegation that they relied upon fake TET certificates, they were not allowed to discharge their duties. Considering the entire aspect of the matter as indicated above, where there are serious allegations against a petitioner of having obtained the appointment as teachers based upon fake TET certificates, and further of the respondents not following the due procedure of law as indicated by themselves in the order of suspension, that is 6/10/2022, we are unable to accept the order of termination dated 26/12/2022 in the present form. And accordingly, upon the prima facie case being made out, considering the balance of convenience and the irreparable loss that the petitioner may suffer, the order dated 26/2/2022 shall remain stayed. The implication, we further provide that the implication of the order of termination dated 26/2/2022 remaining stayed would be that the order of suspension dated 6/10/2021 would be in force, meaning thereby that the petitioners would be under suspension. As the allegation against the petitioner is serious enough for them not to continue in service, and in fact, not to have been appointed at all, we further required the Director of Education BTC to forthwith initiate a proceeding under Rule 9 of the rules of 1964 against the petitioner and complete the same at the earliest in the interest of public, and pass appropriate orders as may be deemed appropriate in the proceeding. The materials referred in the order dated 26/12/2022 may be put across to the petitioner in such proceeding for them to controvert the same and be used as materials by the disciplinary authority for initiating the proceeding. And the petitioners are also directed to cooperate with the authorities in the proceeding if initiated and not to delay the proceeding as per their convenience. Issue notice 6 weeks.
Lordship, one aspect is that the impugn order involves 36%. And here Lordship only 10% has come.
11.
11.
As with
State in respect to the petitioners.
petition. And one more respect to that PS case, it is CID PS.
CID police station case converts to.
And they may also consider my subsistence allowance. They may not pay me.
No, we have tell you, if they don't give you, come to us. Why should he preempt and presume that they will not pay you? If
No,
they don't
earlier
pay
they
you,
did not pay, that is right. The earlier part.
Lordship, that's a different aspect.
suppose one man committed burglary earlier. Today there is another burglar in a house. Will you arrest that man?
Obviously not.
Earlier he done, so today also he only must have done it. You cannot do it.
I leave it.
If they do, you tell us, we'll definitely. And complete it at the shortest time.
Yes.
As we have stayed an order of termination, we also required a director of BTC to act forthwith and if advised, complete the proceeding within the shortest possible time.
Much.
Petitioner hearing was appointed as a lecturer, assistant professor Milot at the college in Bodo language. And since there was no vacancy, no sanction post Milot by the government, they were allowed to work as part-time Milot. And they, in that way, they continued for more than 10-12 years Milot. And now presently. the
Some
government has-
respondent of 5 is appointed.
My lord. The government has now sanctioned the post and in that post, my lord, bypassing our claim, my lord, they have appointed another. In a similar case, my lord, the honorable court has already issued a notice.
In which case? Similar
In
case.
another case, my lord, page 33,
Annexure I.
annexure J, my lord. 34 is the order.
No.
I is this selection.
No, order of respondent number 5, annexure
Annexure 5.
I.
That your lordship will find at page 31,
Third,
top 230
27,
serial. 230 serial.
230. This was, Mr. Upamendu, this was appointed after some selection process.
Yes, college held the selection.
College, did the petitioner participate?
That information I don't have, my lord.
That I will take whether he has participated or not.
If the petitioner had not participated, his right is gone.
Yes.
Only because he was there since earlier, that doesn't mean he will not participate.
That statement has also not been made. Lord.
Sorry.
That statement has not been made, Lord.
That I think he has participated, my lord.
And the registrar gave permission to the qualified advertisement, it had invited walk-in interview. For the petitioner appeared, submitted walk-in interview.
Earlier, it was walking interview, then
Yes, but no, if this person is appointed in a legitimate, acceptable manner, how can we appoint another person in that same post?
Lordship, it was not a sanctioned post, Lordship.
Doesn't matter. If the post is not sanctioned and somebody you have already appointed, when you sanction the post, it will be that man who will get into it.
Lordship,
What happens to the earlier advertisement and earlier appointment?
colleges, my lord, earlier. Now,
Understand?
Lordship, let me take the instruction, Lordship.
Timing we state, let this petitioner continue. Let this petitioner continue for some time.
Lordship, because in the similar.
No.
If he has.
This particular line has attracted our attention that you entered service through a legitimate means. Only thing, post was not sanctioned. What does it mean? Whenever it is sanctioned, it will be his post. Then unceremoniously, without informing him, how can you appoint another person? Or at the best, you could have told him that your initial was not, the complete procedure was not followed. You also participate, come here.
In that case, Lordship, can these matters be taken up?
Because his initial appointment will not vaporize automatically. That the post will become a vacant post.
In that case, Lordship, can it be taken up on 18, Lordship? I'll get the instruction.
Till then, maybe status quo revenge petition.
Let it be
A new man should not be appointed.
I have some difficulty, Milord. Let it be after the vacation then.
18th of this month.
Yes.
I have personal difficulty.
Heard Mr. D.P. Jalia, learned senior counsel for the petitioner. Also heard Mr. D. Upamanyu, learned counsel for the respondents in the higher education department. Mr. P.J. Fugan for Guwahati University. Tejpur, no one is there, na? Guwahati University. Notice returnable on fixed date at DDO. Steps on reservoir 4 and 5, registered post 3 days. The petitioner also to effect justice service on respondent number 4 and 5 through the registry of the court. The petitioner claims to have been appointed as a professor, assistant professor in Boro subject in the respondent Tezpur University, having participated in an advertisement dated 29/4/2013, inviting candidates for a walk-in interview. But at the relevant time when the petitioner was appointed, the post of assistant professor Boro in the respondent Tezpur University was not sanctioned.
Not sanctioned.
And later on it was sanctioned. After the post was sanctioned, the authorities had subjected the post to a recruitment process pursuant to another advertisement dated, is it available?
28th December, Lordship, page 24.
24, to another advertisement dated 28/12/2021, which was in fact a common advertisement for various posts in available in the state of Assam. Oh, who advertised it? Tezpur.
College. Appointing.
Tezpur College. Okay, yours is Tezpur College, not university.
No, yeah. Tezpur College. Dorong College.
Tezpur College.
Dorong College.
Dorong College. Dorong College Kihiba. Tezpur University no.
Dorong College.
If the petitioner was appointed by following a selection procedure pursuant to an advertisement, comma, merely because the post was not sanctioned and later on it was sanctioned, the appointment of the petitioner cannot be obliterated so as to constitute the post after sanction to be a vacant post and subject it to an advertisement. Considering the prima facie case being made out, balance of irreparable loss, a status quo as regards the service of the petitioner be maintained till the next returnable date, meaning thereby that the respondent number 5 who was appointed pursuant to the selection referred above, later selection referred above, be not appointed.
Lordship, it's an advertisement of 2021, Lordship.
21, doesn't matter.
Lordship,
He's already in service. Unless you, by law, this man is removed, the post will not be vacant, I think. Of course, prima facie, we'll hear you on this.
Lordship, similar.
List on so and so.
Next three matters are similar.
20,
not
21
only
and 20.
Colleges are different.
Then please give the particulars.
In 21, Lordship, there is no selection.
Madam, accompanying the learned senior counsel. One order will be typed out, it will be given to you, change the particulars,
Lordship, in 21. Lordship,
factual particulars.
Only in 21, Milord, selection process is not complete. For the
Then what kind of,
disappointment.
that will only pass a list on so and so,
My lord, that will provide.
because the interim will not be there.
Yes.
22.
21.
Item 23.
When you just find out what will be the legal implication of a man being appointed after a selection procedure if the post is not sanctioned and later on it is sanctioned, whether it will become a vacant post as on the after sanction, or the earlier incumbent will have a claim over that post. What do you think?
But there should be a public advertisement.
No.
Since Milord,
Public advertisement is already there,
but that was not. sanctioned. But
not sanctioned.
the status has been changed.
After status change, nothing changes. The status of the man who gets in through a legal process also does not change.
Some candidates may not wish to.
That doesn't mean these arguments will not, it will not hold. Then who asked you to do it that way? No one said you do it in this manner. And this appears to be a advertisement. Initially, I thought that walk-in means no one is informed, whoever walks in is given the appointment. Not that, it's a complete advertisement.
Public notice is there. And
Complete advertisement.
previously, that was the procedure.
The requirement of what is called in the Uma Devina constitutional process is satisfied here. So getting in is legitimate. Post is not sanctioned, now it is sanctioned. So that doesn't mean the legitimate entry will,
So that the ratio will be bigger.
no PRR saying, this is a permanent appointment, that's a difficulty. Appointment is not a ad hoc, PRR saying is ad hoc appointment. Think over properly. And you cannot unceremoniously throw out a man who worked for 10 years after legitimately getting in.
Temporary employee cannot take this.
He is not temporary, he is a permanent employee.
I may not be.
Had the post been not sanctioned, maybe his right to have the post sanctioned may not have been given by law. But once it is sanctioned, you cannot say your appointment is not there. Just next to,
Lordship, it is ad hoc, Lordship. The appointment was ad hoc.
doesn't matter still. Then you should have allowed him to participate there also. Then also it will go.
Item 23.
In this case, Lordship, we were appointed by the Tea Garden Management Authority, Lordship, in Tea Garden schools, Lordship, LP schools, Lordship. Lordship, subsequently, Lordship, authority decided to provincialize the school established by the management, Lordship.
So the schools will be provincialized now.
Schools are being,
Where is the impugn order?
Lordship, page, Lordship 41.
11/9/2023. But they have their with the condition that the services of existing teachers engaged by the garden management will not be provincialized. However, these teachers can continue to serve in the under the payroll of the garden. You continue.
Lordship,
In this connection, just a minute. 2 posts of teachers for each of the LP school. 3 posts for each of the 2 ME school and the ME school shall be created. The students of the schools shall get the benefit of free text.
Post will be created, but our service will be not.
No, but it is very clear, the existing teacher engaged by guardian will not be provincialized.
Lordship, we are the currently.
I understand, but they say he will not be provincialized.
That's why, Lordship.
They say terms of provincialization.
That's why, Lordship.
So the 2 government created posts, now they will hold a new recruitment. At the best, we can say, Madam Phugan, allow this petitioner to also participate if you want.
No, Lordship, already they have without conducting any interview, Lordship, or selection process, Lordship.
Understand.
They are initiated to.
Understand. Now, what are you challenging?
Lordship, that the impugn order dated 18 18.4 and lordship.
18.4. 18.4, if a challenge will issue notice. It's a policy decision of the government.
Subsequently, lordship, under order dated the lordship. 11.9 lordship.
11.9 is what?
60
Selection.
67. New research are being
List of tea gardens, huh? This is only the list of tea gardens.
deploying some research from outside and outside. lordship.
Definitely they'll bring. It's their school now.
Yes, but
See, suppose in your house, you have many different people to do the work. Madam Phukan takes over, says that managing the dining room and the kitchen, I am taking over. She'll bring in her own employees. She is not bound to use your earlier employees.
the fact is, lordship, the LP schools where they are.
It's a policy, Mr. Doloy. It's a policy decision they have taken. Otherwise, they'll say, we will not provincialize. You do whatever you do.
But the schools are not a purely lordship, entire school lordship.
It's a special kind of taking over. That every tea garden school, existing school, we will take over to the extent that 2 posts will be provincialized and we'll provide teachers for that. The rest of the teachers, we are not disturbing them. You will continue to be teachers under the garden. You continue.
If
Where is the illegality?
if they are provincialized to post lordship and they appointing, engaging us, then we have no problem. But
No,
ousting our
you are not ousted.
lordship, they will definitely.
No. Because the terms is clear. They are not going to oust. See, however, these teachers can continue to serve. If the garden wants you, you continue to serve. Your relation is with the garden, not with the government.
At this case, lordship, notice may go, but lordship, in earlier to cases, lordship, there is some protection.
What kind of protection?
Kindly, lordship. Page, lordship, 63, lordship.
63. No, understand what kind of protection?
Oh,
It is, but they can continue. We said, we'll do that same thing. Discontinue and not, or continue is your relation with the tea garden managements. If they retain you, you remain. If they don't retain you, you go. Government has nothing to do with it. And we'll clarify this order, like we did earlier, that government will not oust you. Because they say that you can continue.
There is a contract between the garden and the.
If the garden retains, you can continue. Heard Mr. D. Doloy and counsel for the petitioner, also heard MS N. Phukan for the elementary education department, and Mr. S. Bora for the SSA, for authorities under the SSA. The petitioners herein are all teachers, existing teachers in various LP schools, which were managed by the tea garden authorities, and they have been appointed by the tea garden management, respective tea garden managements. By a notification dated 18/4/2023 of the Secretary to the Government of Assam in the School Education Department, a decision of the authorities is reflected, by which the Government of Assam in the School Education Department will provincialize 2 posts each in the 419 LP schools, 3 posts each in the 2 ME schools, and 5 teachers and 1 headmaster for the high schools. And for the purpose, the post would be created by the government of Assam. But however, the notification of creating the posts for post to effect the decision of provincialization is subjected to condition that the existing teachers engaged by the tea garden management will not be provincialized, but however, they can continue to serve in the same school under the payroll of the concerned tea garden as was earlier, as it earlier existed. Apparently, it appears that this is not a scheme of the government of Assam for a complete provincialization of the schools, but a partial provincialization, that the schools would continue to exist as it existed earlier. But however, certain additional posts would be created, which would be considered to be provincialized posts. And for the purpose, the existing teachers will not have any claim or entitlement. In this threat petition, the petitioners claim that as few posts in the school will be provincialized, such posts should be utilized from amongst the existing teachers and not otherwise. But it appears that the the claim of the petitioner is in conflict with the provision of the notification itself, which is noticed as indicated above. From such point of view, in the interim, it is provided that the services of the petitioners who were appointed by the garden management, respective garden managers, shall not be dispensed with by the authorities in the school education department of the government of Assam by referring to the notification dated 18/4/2023. But however, their further continuance would be subject to the respective determinations as may be made by the respective garden management committee under whom they were appointed. It's a final order or an interim order? With the aforesaid clarification, the claim for interim order is or what do you do with or you want to issue notice? Issue notice, return about 6 weeks, extra copies 3 days.
24.
Better relates to completion at amendment.
Page number, DLC,
Not.
Not.
Page 25 mechanism.
not placed.
Not.
It will not place order to DDO. Give the details.
25.
25, yes. Compassionate,
Yes.
placed or not placed?
Yes, Lordship.
Which page?
SLC rejected, Lordship.
Where is the rejection?
Rejection, Lordship. SLC rejected page relevant page 42, Lordship.
42. And where is the DLC?
TLC, Lordship, relevant page 30, Lordship.
30. What is the
Serial
name of
number-
this man? Syeda.
Saida Nur
Syeda
Akhtar,
is serial number?
11, page 30, Lordship.
Is? No, SLC
SLC, Lordship, page 42, serial number 9, Lordship.
9. Syeda that Akhtara.
Yes, Lordship.
Heard Mr. N. Hussain, Land Counsel for the petitioner, also heard Mr. P. Sekia for Deputy Commissioner and Chief Secretary Aruvegi. Ganesh Pegu for Elementary Education Department. The husband of petitioner Abdul Hai, who was an assistant teacher in the Somukha Anchalik Provincialized MEM school in the Kamrup district, died in harness on 26/8/2012, and on his death, The petitioner submitted an application for compassionate appointment on
Date is not,
when did you submit, Mr. Hussain?
date is not available.
Submitted an
minutes also.
application for compassionate appointment. The said application was considered by the DLC of Kamrup district in its meeting dated
17/3/2020.
17/3,
2020.
2020, and there is a recommendation in favor of the petitioner. Against what post? Against the 10 vacant posts of grade 4 that were available for the period 2012 to 2013. When the recommendation made by the DLC was placed before the SLC in its meeting of, what is the date?
6/8/2022.
6/8,
2022.
2022, the recommendation made in favor of petition was rejected by providing as extracted. It appears that the SLC rejected on the ground that 3 years of balance service was not available in respect of the deceased husband of the petitioner. The provision for 3 years balance service is available in which OM?
1/6/2015.
In the OM dated 1/6/2015. But in the meantime, by the judgment dated so-and-so in WBC so-and-so, so in Omuk versus Omuk, the provision of 3 years balance service had been set aside. In view of the above matter, remanded back to the SLC for a fresh consideration of the recommendation made in favor of the petitioner by taking note that the requirement of 3 years of balance service had in the meantime been interfered by the court in the judgment dated so-and-so, to be placed before the next available SLC.
Lordship, as per page 48, Lordship, admit card of the deceased, Lordship, it is more than 7 years.
No, they rejected only on,
Calculation.
it is also stated by Mr. N. Hussain that the deceased husband of the petitioner had more than 7 years of service left, and even the factual assertion of less than 3 years balance service by the SLC was incorrect. SLC take note of the aforesaid circumstance also.
26.
Yes, Mr. Hazarika.
DLC rejected, my lord. Page 21, my lord, DLC rejected.
21. On what ground?
My lord, 2 years left, my lord. My lord, it is written there, but could not be.
Who is this man?
recognized for want of
Inamul.
vacancy.
Where is Inamul? Inamul.
Page 21, Imamul Haq to, my lord, at third paragraph from bottom. Okay. Till number 2.
Same order, Mr. Saikya.
Initially, he has placed, but initially proposal has been considered by the DLC. but
By which you were not stated.
There's no-
When you considered and rejected, not stated. As Hazarika.
12 and 14.
The father of the petitioner, Rafiq Ali, was a chowkidar in the BTME madrasa in the Kamrup district, died in harness on 21/2/2010, and on his death, the petitioner submitted an application for 16/6/2010. The said application was considered by the DLC of
27/3/2012
27/3/2012,
and
but was rejected by providing that
due to want of vacancies.
just a minute, was 12/10/2015, huh? But was rejected that on the ground that the earlier DLC of 27/3/2012 and 36/2014 had not recommended the petitioner for want of vacancy, and in the meantime, 2 years have passed by, and therefore there is no further requirement of any consideration. we are in agreement with the reasoning of the DLC in as much as the application was earlier rejected for one vacancy and remained pending for 2 years and therefore cannot be given any further consideration. But however, under clause 15 of the OM dated 1/6/2015, there is also a requirement of the department where the deceased was working to take up the matter with the other administrative departments of the district as to whether any vacant post is available for compassionate appointment. And if he has to consider against such vacancy, as the aforesaid exercise was not taken, remanded back. The district elementary education officer, Kamrup, is directed to take up the matter with the other administrative departments of the district to explore as to whether any vacant post is available for compassionate appointment. And if the result, and if it results in any vacant post being available, the matter be again placed before the DLC for its consideration.
I'm deeply obliged.
Anomalies which he is apprehending in the selection procedure that might have taken place in pursuant to the advertisement dated 15/3/2023.
No, illegally taken place or apprehension.
There is an apprehension because of the fact that an impugned list has been already uploaded by the respondent number 2, where one particular candidate name is reflecting, and he being in the list in the interview that was conducted by the respondent authorities, he has done very well. He has got the academic excellence, and he knows that one particular private respondent, that is Sobita Das, her name is reflecting in that particular impugned list. That is in page number 36, ma'am. Page number 36. This is the list of the pending appointment of grade 4 of the provincialized government model colleges for the sanction.
Due to administering. Your serial number?
Serial number 4, my lord.
4.
That-
Sobita Das.
Yes. So basically now what has happened is that as per the
So you are challenging selection of Sobita Das.
Sobita Das, selection of Sobita Das, including that list which has been published by the
On what ground you challenge?
on the ground of the fact that since he has done quite well in the interview and the final results have not yet been declared. And now this has been.
Your Medhi,
Yes, please, my-
Mr. Wire Medhi. According to you, you are a good advocate or a bad advocate?
my lord.
You are a good advocate.
No, my lord, with limited.
No, whatever. Everybody thinks I am good. Petitioner also thinks he has done very well. So every thinking of a participant or a candidate that I am better, I have done well, you have appointed so and so,
Right.
cannot be a
Absolutely.
basis for a court to interfere in any manner,
Absolutely.
unless you show that some illegality had already taken place.
Yes, my lord.
Please submit from that point of view.
Yes, my lord, the fact that I had already sought for the documents from the respondent authorities by doing RTI. Already, it is in the first appeal. It is pending, and I have not got the sufficient answers I was looking for. Because of the fact that the interview.
We can dispose of this writ petition, directing me to provide the answer today. You examine what the material, then come back with another writ petition. Mr. Mehdi, these will be fundamentally difficult
Yes,
because tomorrow anybody can come to the court that this is my apprehension, this is my view, this is this thing, that there is illegality there. Please call for the record.
yes, my lord, that is my.
We cannot do it. This is precisely, we can't do it.
No,
Because in every matter, burden is on the petitioner to show
Yes.
his right and what illegality had taken place. Merely raising an allegation that please produce the records, now let the court verify, that is not permissible in 226.
Yes, my lord.
So we can meet your grievance to the extent that whatever document you want, whatever material you want, we direct them to give it to you.
Yes, my lord, that will do. And at the same time.
Then you examine, find
Yes, yes.
illegality, you come back.
Yes, my lord. And declaration of the results. also.
Where is your application for the materials?
And page number. 13, page number 39 is my first application, ma'am.
39 is your application.
Yes, which I have sought under RTI.
We convert this writ petition to be a writ petition for the purpose of RTI and pass this order. Get the documents, find out
Yes.
what illegality and you file a.
Yes, that will do. And one more, my lord, regarding the declaration of the results. The results. It is pending, my lord, or already.
Understand, how can you interfere unless some illegality is pointed out? Heard Mr. W.R.
Yes.
Medil and counsel for the petitioner also heard. Higher education, who appears? The higher education, considering the nature of the order proposed to be passed, notice not required to be issued to respondent 3, 4, 5, and 6 for the present. This writ petition is instituted.
Lordship, our name was not shown. You have picked the file.
We have seen you.
Costly also.
Mr. Gogoi, I have already seen you. That is good enough.
Lordship,
Your presence is more than your name.
Lordship.
This writ petition has been instituted with the following prayer. A reading of the prayer makes it discernible that certain select list purported to have been prepared by the respondent authorities for appointment to grade 4 post in the provincialized stroke PDUAM stroke government models colleges. Line 2. What's start? Is being assailed. The petitioner particularly assails the selection of the respondent number 5, Hobita Das.
6.
This was 6, Hobita Das, in respect of Bhawanipur Anchalik College. Although the list referred in paragraph page 36 is a list of pending appointment, and in respect of Sobita Das, there is a reason stated that the appointment had not been made as because administrative approval was not received. According to the petitioner, the respondents ought to have selected him considering his acumen and performance in the selection process, but instead it is the respondent number 6 who had been selected. No material could be pointed out by the petitioner as to why the selection is vitiated in law. As an answer to that, Mr. W.R. Medil and counter petitioner states that the petitioners have sought for the relevant information under the RTI Act of 2005 from the principal of Bhawanipur Anchalik College. But such informations are not being provided, and this is the reason as to why the petitioner cannot point out the precise reason as to why he is of the view that the selection itself is vitiated. From that point of view, from the said aspect, we are of the view that the petitioner has a legal right under the RTI Act of 2005 to be provided with the information, and it is noticed that the application is already dated 2/8/2023. As the information that may be provided under the RTI would be the basis for the petitioner to assail a selection, we are of the view that instead of going by the procedural requirements under the RTI Act, the ends of justice should be met on a direction being issued to the principal in charge of Bhawanipur Anchalik College to consider the application of the petitioner under the RTI Act dated 2005 dated 2023 under the RTA to seeking for certain documents and to provide the petitioner with the necessary documents. As Bhawanipur's college is stated to be a provincialized college, we are the view that the principal can also be represented by the Learned Standing Council for the Higher Education Department, and accordingly, we require Mr. K. Gogoi to also appear for the principal of the college. Accordingly, the principal in charge of Bhawanipur Anchalik College is directed to provide the information as sought for by the application dated 2/8/2023 under the RTI. If otherwise, such information is required to be provided under the RTI Act. If the principal do not intend to do not provide the information, any of the information, a reason thereof should be stated as to why under the RTI such information are not required to be provided to the petitioner.
My lord, also taking note of phase 42.
What is 42?
Phase 42, director also directed the principal.
It is noticed that
Phase 42.
that by director has already given.
Lordship, phase 42.
Because information we feel should not be withheld. Later on, we'll see what selection is done, what is not done.
Phase 42, lordship.
You also take note that the director of Higher Education Assam had also directed the principal of Bhawanipur Anchalik College by the communication 29/2023 to provide the information to the petitioner under the RTI as sought for. Accordingly, the information be provided in a period of 7 days from the date of receipt of the certified copy of the order. Right. Upon receipt of the information, if so advised, liberty remains with the petitioner. We approach again.
Disposal.
Disposal.
Today I communicated.
Liberty remains because he challenged something else, so we did not decide. Thank you. A.Y. Chaudhary, yes.
In this matter, appearing on behalf of A.Y. Chaudhary. Yes, I have the instruction that he is not pressing this with liberty, withdraw this petition with liberty.
But either A.Y. or T.A.,
For this,
not Mr. Mira.
today I have filed wakalatnama for this purpose.
Okay, you had filed wakalatnama. Mr. K. Mira Learned Council appears before the court and has submitted that he had filed a wakalatnama on behalf of the writ petitioner Amir Hussain Chaudhary. It is also stated by Mr. K. Mira Learned Council that there is an instruction from the petitioner Amir Hussain Chaudhary not to press with this writ petition in the present form. Accordingly, writ petition closed on being not pressed, liberty granted to approach again if so advised. Mr. Gogoi, this is what, medical or what? SSA. Baki video Gogoi SSA and Pogan education. The document pertaining to filing of wakalatnama is kept on record.
29.
And 31 have taken.
20.
29 and 31. Also, very matter of.
Release monthly salary allowances with effect 2009.
But I marry your worship is occasion to deal with the matter that something with the way. Your hospital, file your hospital occasion page 77.
No, today what do we do? Notice or some interim order?
Yeah, you will come with the direction to dispose the matter and they have disposed.
Pending disposal, please to restrain her from filling up the post.
Page 75.
Yes, Mr. Kaushik, what do you say? Did you pass the interim order?
Look, at this stage, let notice be issued, madam, because a speaking order has been passed by the director rejecting the claim. Perhaps this will require an adjudication order.
What is the claim of the petitioner? But is this fact recorded correct? That the petitioner was appointed by managing committee after
Yes,
provincialization.
yes, correct.
But that is a,
It is a minority institution. Madam. This is a minority institution, madam, managing committee has the right, which could also help, madam. This honorable high court also held it.
it is still a minority institution. It is still a minority
Yes.
institution. Is it provincialized?
Yes, provincial.
But provincialized and minority don't go hand in hand.
Yes.
With the worship of the government, one day, what kind of government can
No,
do?
no, let us see the provincialization act.
Here.
Because same thing happened in another institute, I remember.
Uh,
That either you accept provincialization or you
Or you
accept
retain the
minority,
position.
either of the two
Yes.
three of us,
of the
employees of the police.
act,
Subject to-
the act of which act? 77 act from Kota say. Is it available in this book?
Yes.
Page number?
Page 352, madam.
350.
This is the book part of 355.
See the color? Ah, same.
Okay.
355.
Universal color.
This is Mr. Torun Jhotia color. I think it is his book, I think. Now it has become very popular.
Yeah, but it is page 355.
355.
The worship order.
Mhm. What decision did we deliver earlier?
Yes, the one hundred
Please.
page 30, start from that Supreme Court decision.
Page number,
Same school, same school.
page number
Start from page 30.
13.
That question is
Hmm,
Page 35.
35. Whose judgment? My judgment? Is it my judgment or Supreme Court order?
From the same school,
Page
page 35.
35, regarding the same school.
You same school. The motion by soil and social consequence and response. For the individual solution. But for the main by the volume by that. We have, what is the finding of the high court? The administration was.
Were you reading page 35?
Page
35, which line?
35, second, third line.
It was a Hindi language institution, but was managed by who had their own language.
Most finding we have.
No, ultimately, what is the finding of the Supreme? Hmm.
We have. No appeal has been recorded against that ending. It is therefore not open to the. There you must find. Please, some.
No, can you read the whole of the Supreme Court order? Maybe must have. Relate to virus of section 5 of the act. What is the virus of section 5? The administration and the control of all employees of the within the purvey shall be vested in the state government. So, section 5 has been challenged. Section 5 is held to be ultra virus. Ultra virus, article 30.
So they have come with us.
No, but Mr. Chaudhary, why we are asking you so much? What is a section 3? Subject to provisions of article 30 on and from appointed day all employees. So if it is subject to article 30, you are not provincialized. The act itself creates a legal fiction that all institutions subject to Article 30, all schools are provincialized. Means if you're subject to Article 30, you are not provincialized.
So that 40 year was under also very important. In this case.
In this case itself,
In this case. still no-
because it was argued by somebody.
Yes. And your worship was there. Yeah, different.
Huh.
In that time, your worship was-
Then what is the answer to that?
No, that question mark is the same, it's schools are already provincial. But it is-
So no.
it is applicable to minority schools.
No. This is not, this is a, but there is a legal fiction already created that only those institutes are provincialized who are not subjected to Article 30.
That is, that to look.
So either that, no, this is a very difficult issue. Article 30 gives a minority institution every right to exist, function in their own way. They can make their own rules, they can function in their own way, nobody can prevent them. So therefore, they should not be provincialized, they should not be touched. So when the government wants to provincialize, they say subject to the Article 30.
That is supposed to be there when government cannot take any decision or make a case.
No, they are not government school at all. You cannot take.
They can have finance from the government. But cannot make a decision.
No. Government may provide, may not provide, it's their discretion, but one minority institution cannot have the benefit of both, that we'll have all the benefits from the government and we'll also go as per our own wish. Both are not available. You have to choose between the two. If you have chosen for minority, you will be governed absolutely by Article 30. TMA Pi Foundation, the judgment, 7 judge or 9 judge judgment is there. Every law will be in your favor. But you don't get the government benefit. Once you get the government benefit, then you do away with your status as minority and take the government benefit. Then you will be governed by government rules. There cannot be both. You remain. Then government, you can take a decision whether, Mr. Kaushik, you get back to us. What is your decision? You want to continue with the provincialization of the school or not? Don't continue. So section 5 is declared ultra virus for that reason.
For that reason. Or for the.
Because the control will be with the minority institution. So once section 5 is not applicable for minority, the rest, the act itself is not set aside for minority act. 3 will remain. 3 is again subject to. No, because otherwise this will be a very dangerous situation. Everybody will create their own minority institution and also say, government, you give us everything. So, no, they have taken a decision subject to, meaning thereby that you are not subjected to Article 30. But if you now go back and say, I am governed by Article 30, then your provincialization is will be out by, and mind you, Section 3 is a legal fiction. It's a deeming provision. On and from the appointed day, all employees in the 3 shall be deemed to have become. So, but that is except 30. So, so once you say, no, I am at 30, then this deeming provision is not applicable. The law did not provincialize this school. Although mistakenly for many years, your salary had been given, but that will not make it a provincialization. Our attention. So this will not help you.
The managing committee, the school has all from 14 November 72. But it has no objection to the provincialization of the student. Therefore, no objection.
So now, by virtue of this order challenge, this Madhu Agarwala petitioner is claiming that give me salary. Why you pay salary? Salary.
My appointment to
Is-
approved by the government.
Approved.
Should be approved by the government.
Why should the government approve?
Yes,
You are
because it
appointed
is a-
by minority institution, you remain there.
That one management can say, my lord, what is their position. They can say.
Nothing.
So, but I am concerned, I have been appointed. by the-
So, no. Then let the managing committee be say whether they make a statement before the court, whether you are minority or you are provincialized. If you are provincialized,
What is the court can say? The official matters, my question, I have been appointed by the region of.
managing committee. huh?
Committee is the-
So you ask for all the benefit from the managing committee, they'll give you.
I am asking them, but they are, government is providing all the benefits to the other employees.
Because we take
All
the
the
school as a provincialized. school.
Because they accept it to be a
Provincialized.
provincialized, not a minority.
Why should I single out my? Why is singled out?
Mr. Chaudhary, there is also a pending litigation regarding this LOG Hindi High School, Fancy Bazaar. A managing committee of about 10 years back, it's a repetition of 2013, still pending, challenged the provincialization,
Provincialization.
saying that we want to retain our minority status. That managing committee is gone. Now succeeding managing committee says, no, we want provincialization, we don't want minority.
You want to be-
So it is a choice between the two, not both.
That's one the one is required, that can
So
be-
if this managing committee says that no, we opt for provincialization and not for minority, then it will be governed by the rules regarding minority. And regarding Madhu Agarwala, we'll ask them to take a special consideration because she was appointed under a confused state. So let us make a distinction from the regulation appointment by managing committee after provincialization. Because this was a little confused state.
Page 37, the managing committee expresses that they want to be provincialized.
Where is it?
No.
No, it has no objection to the provincialized.
Objection to the provincialization.
So meaning they
So,
want them to be
So it will
provincialized.
be choice, either of the two, not
Yes.
both.
So anyway, one now that has been settled by the Supreme Court, they have said that yes. No motion can that's the next part. Therefore, no objection permitted under the same act will be taken. This submission does not appear to. It been dealt with by the judgment under the.
The petitioner upon hearing Mr. H.A. Chaudhary learns in a council of petitioner, an issue has arisen as to whether the respondent institute, namely Gandhi Vidyapit Hojai, is a minority institution or the school deems itself to be a provincialized school. The issue attains whether they want to be a provincial. The issue arises in view of Section 3 of the Assam Secondary Education Provincialization Act 1977, which provides that subject to the provisions of Article 30 of the Constitution, on and from the appointed day, all employees of all secondary schools in the state of Assam shall be deemed to have become employees of the state government of Assam, with effect from the date of appointment. The Section 3 itself is explicit enough that all schools subject to such schools, all schools all schools other than the schools subject to the provisions of Article 30 are deemed to have been provincialized, which again is a legal fiction. In the circumstance, the respondent school to inform the court as to whether they continue to consider themselves to be a minority institution, so as to exclude themselves from the deeming provision of provincialization of the school, or they intend to avail the benefit of being provincialized under the deeming provision of Section 3, in which case the school have to be excluded from being the school under the category of under Article 30. The petitioner to issue dusty service on the responded school list on 4 and 5 upon appearance of the school managing committee for the aforesaid answer, further orders shall be considered.
Right.
List on so and so immediately after the vacation. Let them come only to the school. We issue notice to the school on the premises that it is the categorical stand of Mr. B. Kaushik, Land Counsel for the Secondary Education Department, that Section 3 of the Act of 1977 would operate in favor of provincialization in the event the institute is not a institution under Article 30, and in the event an institution is an institution under Article 30, the deeming provision of provincialization would not prevail. List on so immediately after vacation. Same order. Because this issue is pending in a number of schools, not only one school.
Article 30, suppose who is there. 8, second there.
8 you get.
Yeah.
8 and provincialization different.
Service.
Provincialization is deemed to be employees of the government of Assam.
Teacher, not a school side.
Ah.
Taking up all the.
Whatever. So that deeming will be not be there. Teachers will be paid by the school then.
School managing
I
committee
am
has to pay.
appointed by the management committee, I am entitled to get.
Understand?
Rest it is in between them.
And you also make your stand clear.
Well.
Whether both can, as per your law, whether both can go hand in hand. If you say yes, we'll accept it. That's why I say. The state response, and he already recorded his response.
But your worship has wanted managing committees to.
If the managing committee comes and say, "My lord, that
Mr.
you don't come
Chaudhary,
within the purview of-"
Mr. Kaushik had already responded before the court. Therefore, we want to have the views of also of the managing committee. Because he says, if you are provincialized, you are not minority, as per our view.
Yes.
If you are minority, then you are not provincialized. That is his view. Because of this view, what the school managing committee wants now, they want provincialization or they want minority. And let us
They're going to fill up the post. Post will vacant.
the post in respect of petitioner shall not be filled up till the next returnable date. Okay, that we can give.
Both the-
Yes, sir.
Item 30.
Where is Mr. Kaushik? B. Kaushik. Item 30, who is appearing?
Item 30.
None appears for the petitioner when the matter is called. List again.
32.
Next week. Adjourn on the prayer of Mr. A. M. Borgohain, petitioner. In view of the submission made that the issue involved has already been decided in an earlier proceeding and the Learned Council intends to produce the said judgment. List again. List again.
34. Order stay vacating.
I'm a school and living school was amalgamated by school. Now, who has the right to do that? And last one communication was regarding the different ways in respect of every school and every school.
Who appears for the government? Because Mr. Abedin will say it is me, Mr. Purag has to say it is me. Now what the government has to say?
Preparing in this case.
Where is he?
Taken after some time, madam.
And nothing is provided in the amalgamation scheme.
No.
For ME and high school, something is provided. LP and ME, nothing is provided. So what can we do? We direct them to take a decision. See, what the courts do, we interpret the law and provide that under the law you are entitled, under the law he is entitled. If the law is not there, we cannot make the law. We ask the government to make the law.
On last revision, my lord, wanted to express that when the pay structure is different.
No, these are our observations are not conclusive. These observations are for taking ahead the deliberation before the court. If it is conclusive, I would have dictated the judgment then and there. I would not have heard you anymore. So questions we put to just to extract out the issue from the parties. Not that that's a conclusive view of the court.
That was one of the criteria. By them, by passing the rule order.
So what can we do? We can ask the government to take a decision, that's all.
Yeah, only because of the pay scale that.
Huh.
Not our.
So let the government take a decision. Whichever way decide, the rights of the parties will be decided accordingly. We can't decide it. We can decide only when the law is there. We can interpret the law, we can give a meaning to the law. And having done so, we can say, so and so has a right or the other one has a right. But if the law is not there, what do you do? If you ask to decide, we'll say both are entitled.
May I just point out one thing?
Where is the law? If you before pointing out, tell us the law, we'll look at the law.
Law is, my lord, absolutely silent, that they, my lord, Pascal is the basis to determine the senior.
So when it is silent, what do we decide?
Then government is the best person. On the other hand, my lord.
Or else we say, maximum we can say both are equally entitled. You be for 6 months, you be for the other 6 months.
My lord, it is absolutely not correct. My lord.
What else will you do?
My lord, Lordship kindly appreciate, my lord. They said in the impugn order that he is, my lord, getting higher get pay. But my lord, in 2019, an order was issued. My lord, my grade pay was made equivalent to his grade pay. This is the order. That was not taken into consideration. He is getting 8,400.
No, first you have to tell us the law. Because the amalgamation scheme does not provide for anything
My lord.
regarding the respective rights
My lord.
when the amalgamation is between a LP school and a ME school.
My lord.
Rest of the schools, everything is provided.
Everything is covered.
So we asked the framer of the scheme to look into it and do something.
My lord, at least, my lord, there are 2 notifications issued saying that, my lord, in the event of amalgamation, my lord, the employees of LP school shall be deemed to be in the cadre of ME school. And they are not supposed to lose their seniority. Therefore, my lord, the question is, my lord, that by virtue of that particular clause of the notification, my lord, all these staffs of the school shall be.
What to
deemed-
do? Okay, we'll hear the matter. It will need a detailed hearing. If you want us to hear.
You have all worship.
We can't decide the vacating the interim order in this truncated manner. Whatever is there, let it remain.
Yes, and matter may be hard after vacation.
Now, who is holding the charge?
My lord, BO.
Will not allow either of the two to hold the charge.
No.
Or else we send it back to the government to determine the issue.
Actually, lordship, please.
I think that will be better.
It will be better, my lord.
Otherwise, neither of you two will be benefited.
Or should just make an observation that they should take into consideration all relevant facts. all records.
Everything, whatever they provide for.
It will be better.
Say, suppose when there is an amalgamation between ME and higher secondary school, the ME man has the right to be the vice principal. After being vice principal for 5 years, he also has the right to be a principal.
My lord.
But the graduate teacher in a ME section having 10 or 17 years of experience can also be directly become the principal. Why? It is provided in the scheme. But here nothing is provided. So let them determine the terms. Heard Mr. Who is for the petitioner? Mr. Progressor, you are for the petitioner.
I'm for the petition.
Which positive order in the IA or in the writ? Heard Mr. J. Abedin, learned counsel for the applicant. Also heard Mr. A.K. Porokasto, learned counsel for the writ petitioner. Mr. A. Phukan for the respondents in the elementary education department. Mr. S. Bora for the authorities and the in the Department of Education, BTC. Also. The petitioner is an assistant teacher. Is no, was an assistant teacher in the Kosari Dag ME school, having been appointed on 18/1/1989. The writ petitioner, on the other hand, where are your particulars?
10/1990.
On the other hand, is an assistant teacher in the what LP school? Was an assistant teacher in नाम तो लिखी दी वो हाँ in the Omuk LP school, having been appointed in on
20/10/1993.
20/10/1993. Subsequently, both the schools were provincialized. Subsequently, or earlier. Subsequently, both the schools were provincialized. But thereafter, by the order dated, where is the amalgamation order? 22/1/2018. The LP school of Namtulikha was amalgamated with the ME school with the Namduta Lediba. The amalgamation is admittedly as per the where is the amalgamation scheme? Page 52.
Page 52. That's a selected.
Amalgamation scheme provided in the office memorandum dated 3/8/2021.
Page 27.
27.
Is the order.
No, I want to take a look at the scheme.
Scheme.
Huh.
Alright, scheme. Yeah.
Where is the scheme under which it was amalgamated? It will blank video, huh? We also noticed that there is a subsequent scheme of amalgamation and merger of different schools as per the OM dated 3/8/2021. Although the merger of the two schools may not have taken place under the said OM. In this writ petition, is a dispute between the applicant in the interlocutory application and the writ petitioner as to who should be the headmaster of the amalgamated school, amalgamated ME school. In this respect, where is the impugn order? Page number. Writ petition page number 50. There is a there is an order dated 28/6/2023 of the Director of Education BTC, whereby a factual determination was arrived that the scale of pay of the writ petitioner Sunil Kumar Das. What is the scale of pay of Sunil Das? Mr. Bora, Mr. Bora, I understand that. Does the computer of the BTC does not allow a bigger font? Why don't you write this? How can you read this one? Ask him. Hmm. It's very difficult to read. The font is so small and the gap between the two lines is almost touching with each other. So 47 is that type copy. But whoever typed out also must have had problem. So it's better if the original one is typed in a better way. Uh,
22/1/2018. That was the amalgamation scheme.
20 to 1 2018 first. Now, where is the scale of pay of the petitioner? 48. Which line? Key petitioner is that the pay of the writ petitioner Omok is rupees 7400 as a trained graduate teacher, whereas the pay of the applicant Asit Kumar Bhomik is rupees 8,700 per month. Accordingly, as the writ petitioner was found that his scale of pay is rupees 7400 per month, whereas the scale of pay of the applicant Asit Kumar Bhomik is 8,700 per month. Therefore, the applicant, having been paid a higher scale of pay, was held to have been entitled to the post of headmaster of the amalgamated school. Mr. A.K. Purokayastol and counsel also point out that by a subsequent order
Dated 29/8/2019.
28/9/2019, the
29/8.
29/8/2019, the scale of pay of the writ petitioner
Was upgraded
Sunil Kumar Das was also upgraded
with effect from 1/4/2019.
with effect from 1/4/2019. We have noticed the two schemes of amalgamation, wherein the respective rights of the teachers after amalgamation, depending on the category of school, had been crystallized and clearly provided. But the respective rights of the teachers upon a LP school being amalgamated with a ME school had not been clearly provided in either of the two schemes. In the absence of any such provision, it is difficult to determine the respective legal rights claim as to who ought to be the headmaster between the writ petitioner, who is admittedly a teacher of the erstwhile LP school prior to the amalgamation, and the applicant, a teacher of the erstwhile ME school prior to the amalgamation, where both are presently teachers of the amalgamated ME school. As it is for the framers of the scheme of amalgamation to provide the respective rights of the teachers after such amalgamation, and the same having not been provided in either of the two schemes, we direct the Director of Elementary Education Assam, or who had made the schemes? Who? Under whose signature the schemes are issued? Director Omuk Jone ase. Principal Secretary to the Government of Assam in the presently in the School Education Department, to Secretary to in the School Education Department to examine the two schemes of amalgamation and provide for a definite provision as regards the rights and entitlements of the teachers of the LP school and the ME school after the schools are amalgamated. Whatever entitlements and legal entitlements are determined by the secretary upon considering the matters shall govern the writ petitioner and the applicant in respect of their claims to be the headmaster of the school concerned of the amalgamated school. The secretary to the education department is accordingly directed to do the needful within a period of 1 month from the date of receipt of the certified copy of the order. And upon the respective entitlements being determined in relation to the schemes of amalgamation, the director of elementary education, or the director BTC shall give a hearing to the petitioner and the applicant and pass a reasoned order as to who between the two should be the headmaster of the amalgamated Omuk ME school. Okay.
We may be given the liberty to file representation.
Sorry. Thus, where will you file representation?
Before the authority.
No, you have no right. It is their prerogative to decide. Once the decision is taken, you have right to appear before the director. Once the decision is taken by the secretary regarding entitlement, the petitioner and the applicant both be given a hearing by the director while deciding upon their respective claims to be the headmaster. That's the BTC. For that, you have a hearing. But what they will decide, how can you decide? IA so and so disposed of accordingly in view of the order in IA, no further order required in the writ petition, accordingly closed.
35 for admission.
It is stated that presently there no one is holding the post. It is stated that presently neither the writ petitioner nor the applicant in the IA is holding the post of the headmaster. So 1 month you continue like this. Sorry. What is the present arrangement? And it is stated that the concerned block elementary education officer is discharging the said status be continue.
Yes.
Till the decision is taken by the Director of Education BTC. Some forensic report. To what forensic report?
We are yet to receive, but from the CID report we have received, my lord. So it is, he is joined in the health department.
Oh, one man, he joined somewhere and he says that I did not join.
That.
And one document produced the police, he questions that I never gave this one. So now we have some report that he had joined. File an affidavit. Mr. Girin Pegu, Land Counsel for the Land Additional Senior Advocate appearing for the Home Department of the Government of Assam, has produced a report provided by the CID, which states that materials are available that the writ petitioner had joined as I think he was selected for compassionate appointment. He was working somewhere else at that time. It's something like that.
In the health department, my lord.
In the health department of the government of Assam. The say the materials be brought on record by way of an affidavit.
My lord.
List on so and so after the vacation. The affidavit, the affidavit be filed 1 week prior to that date of the DDBO, and the petitioner may file their response if so advised before the next returnable date.
15 November.
15 November. So file it around 7th, 8th November.
Item 36.
Date you take up this. This 36.
23rd November.
Conducted into the affair of the election.
Or that the two answers. Two answers. Duplicate answers. Yes, let us close this. How do you want to mitigate his grievance? You make a suggestion. If Mr. Goswami agrees, we'll, otherwise, what will he decide?
And it's very important.
Hmm.
Volume.
Now, how do you see? It's almost conclusive now. Even we have seen it that yes, there are two tick marks. There is no material to show that it was done by the petitioner himself. Number one, there is no logic to show that the petitioner do it himself to his own detriment. No candidate will do that. That to my detriment, let me tick mark 2 so that I don't get 0 in this answer. No one will do it. If he doesn't know the answer, he will take a chance. Let me at random put A. If A is the right answer, I get the marks. If it is wrong, I'll get none marks. But no one will jeopardize his own case of giving 2 tick marks. So both goes against our state. So how do you mitigate him? The respondents, upon hearing the matter and considering the inquiry reports available on record, it appears that the answer scripts of the writ petitioner did contain 2 tick marks as answers in respect of one question. And further, there is no material to show that the double ticking was done by the writ petitioner himself. Secondly, we see no logical reasoning as to why the petitioner would also give 2 tick marks against the same answer in his answer script to invite the detriment of not getting any marks in the question, where he has the option of making a random tick on his guess and waiting for his chance as to whether that ticking would be right or wrong. In the circumstance, the respondents in which department? To explain as to how the grievance of the petitioner can be mitigated. May submit on how it can be mitigated. List on swings. You tell us how you want to mitigate him.
Otherwise, his prayer is now, will respond. I think when this report which has come from the CID, let me take the view of the department. How do they want to, as your lordship is saying, how do they?
How do you want to mitigate? Or if you want to challenge that one, you challenge it. If you want to challenge the
Yes,
CID
the
report.
department says that we do not accept it. Let them see. Let us see how do they want. Otherwise,
No, merely we don't accept it will not.
No, that will not.
That will not serve the purpose.
In view of
Because
this,
sometimes a lot of people come and say, no, I have not done it.
that will not.
That kind of answer we don't expect.
On facts, if they want to say something, that's different.
At the best, department can question the report of the CID.
Right.
It is factually incorrect.
Right.
That you
Yes.
can do it. But you can't say that
We
whatever
don't
happened, we don't know.
No, that.
We won't allow that. But difficulty is
Right.
one undeserving man is serving in the department somewhere. That is more disturbing. We don't know who it is.
At least so
It
far as
must have been done at the behest of somebody.
a lot of-
A departmental official has no business to oust one particular candidate
without any.
unless he has a candidate of the choice of his own. No official will do it.
We are reported.
List on when do you want?
Let us have some time, 1 month and whatever they want to say.
We have taken one.
No, now what will happen is this report on this, they will have to make their own comments. If they accept, then naturally. consider
Date
will
এটা
follow.
দিয়ে যাও, আজকে কি মান?
Territory.
আজি 13 তারিখ। November 13?
November.
Oh, it's a holiday. November 14?
This will be November 16, there are 2 matters. 16.
16 will be a better date.
For me, my lord, because 2-3 matters are taken for.
Okay.
I'll take,
Or you follow astrology, numerology and all, no, not that.
my learned friend follows.
But he did
I
not
follow
object.
him, but
He did not object. Otherwise,
Once he said-
otherwise he would have said, no, make it on 17th.
I follow him.
Okay, you come back. Thank you.
37, 38.
May I pray for some accommodation to the member? Lordship wanted a
Adjourn on the prayer of Mr. B. Kaushik and on the secondary.
second after the vacate.
39 and 40.
Yes.
May pleases your lordship. We have filed our affidavit, your lordship. That has came in the records, your lordship. Wait, you acknowledge? I saw a not.
Yes, so what is to be done today?
Your lordship, kindly,
Hmm?
final hearing, your lordship.
Okay. It stated that the proceedings are over and the matter can be given a final consideration. Less constituency has agreed.
41.
Give your best. The eight were in fact-
41 as below score. Yes, your man. 41 what is to be done? 3 weeks time to Pegu. Notice issued. Yes, you want to file affidavit? Elementary education. Mr. B. Kaushik, prays for how much time to file affidavit? Pray now.
42.
D.K. Sharma.
39, 42. List out of it. এটু কি বলে?
My learned Mr. Kyle, for 9 for
But where is Mr. KL today?
on the last occasion. Here, I have to wait for last of my lord, the matter.
No, what can we do today?
My lord,
It stated inside received an NOC to the period could not be issued, but there is an allegation of misappropriation of certain.
kindly see the.
Where is Mr. KL gone?
My senior is out of station. He has received some instruction, lordship.
Last day, that was the sub.
But he cannot force it on them. It's some serious allegation. Which have.
My lord, whatever the allegation, my lord, I have applied for a post in the other university with, by taking, my lord, NOC was taken. When my lord, I have been elected, I have applied for DA. Then only I came to know that, they say cannot be released because some vigilance inquiry is here.
Understand, but on which date you will complete? Because here's some urgency.
Lordship. Next week, lordship.
Next week,
Lordship, CBI has submitted the report to UGC.
CBI.
Yes, Lordship, UGC.
He has gone to the CBI.
Yes, CBI has submitted
Your name?
MDEC.
MSM Dekha, appearing for the Assam University, states that the necessary instructions has been received
Yes, sir.
and the respondents intend to file an affidavit. Mr. D.K. Sharma, like our petitioner, expresses urgency in his as the petitioner had been selected an appointment in some other post, but the NOC is not being issued. Full stop. MSM Decca Land Council for the Assam University, on the other hand, states that there are certain allegations of misappropriation of fund against a petitioner, and in this respect, there is also a report by the CBI. The affidavit and the complete materials against the petitioner be produced on the next returnable date. List also ends.
7 November. 43.
What is 43? Yes. We want to hear this matter again because at the time of signing, I have noticed something.
Right.
So that earlier order may not be the most appropriate order. So we recalled it, listed it again. We want to hear both the parties. Where is Mr. Kane Chaudhary?
We have informed my lord.
He'll be coming. Okay, let him come. Because both ways we find little difficulty. If I refuse the interim order, one extreme form of a order would be there. If I grant interim order, reverse will be true, extreme in the other way. So we have to do something in between. So therefore we want to hear you.
To balance the
Hmm.
balance the situation, my lord, I in fact proposed that the 17 posts were recommended. One person has already retired, so one post can be kept vacant. Lordship can take up.
No, one post, that is not the issue. Issue he is raising is that for these posts, you need a PhD or a PhD. And his argument is based on the NCET regulation. Your submission is Government of Assam had not adopted NCET. But
Adopted it for the direct,
no,
for the,
no.
to the extent of direct. replacement.
Possibly for NTC, that may not be the law. For UGC, yes. Whether you adopted and how much you have adopted. NTC, possibly the law is that option to adopt or not adopt is not there. It is applicable. Possibly. So this is the reason why.
This issue has been deliberately.
No, we don't know. Just some earlier thought came to my mind. Ah.
The NCP guideline, regulation, respondents don't have the qualification.
No, I understand. So the basic question you have raised is NCT regulation had not been adopted. But if the law is, there is no requirement to adopt NTC, it is applicable. Then the picture will be a little different. So I want to hear you on that, both the parties. And then pass whatever order required. After some time. Okay.
44 for orders.
After 3 weeks. On the prayer of MS has to tell and counsel for the petitioner list after 3 weeks.
45.
Years, you're there? Huh? What is to be done? Affidavit file, no. Elementary education, you want to file affidavit?
Yes.
Mr. B. Kaushik prays for 2 weeks time to file affidavit, pray law list after 2 weeks.
46.
Right. It's stated that Mr. S. Kejriwal is in very bad, therefore an adjournment sought for prayer law. Take your take.
47.
Union of India review. What?
Respondent opposite party lordship applied for an appointment as a constable with the CRPF lordship. That's the last.
Did you issue notice?
No, not
Let us issue notice. Heard Mr. B. Chakraborty, Land Counsel for the Land CGC for the petitioner notice. Now, how much? 4 weeks till almost returnable 4 weeks. Steps on responded result post 3 days. Any interim order?
Lordship directed for review, medical examination, because we have already conducted prior to
Okay,
coming to the.
prior to the order, so that order is of no value, means neither, okay.
48.
48. Review, yes, Mr. Majumdar. Review for what purpose? No, on what ground review?
Decided by Konabi.
23.
No, I'm not understand. On what ground you file a review? What is wrong with that order?
Wrong, but there is subsequent development and that's why there is error. Otherwise.
Subsequent development could not be brought to the notice of the court. Subsequent development that took place prior to the judgment or after the judgment. After the judgment is not a review. Mr. Whatever it is, any subsequent development after the judgment cannot be a review because the order and the review cannot be wrong. Because we could not have foreseen the future, that in future something else will happen. So this order cannot be wrong. At the best, it can be appeal, I think. Appellate court can again send it back. But we cannot review. Understood? Today we are adjourning it, you examine the matter. A review order can be wrong only when relevant materials, even after due diligence, could not be placed before the court, or some relevant provision of law could not be placed. Both has to be existing on the day of the order, not future. Future cannot review jurisdiction is not available. Remedy is appeal that after the order this had happened, this fact should have led to a different order, set aside, decide it once again. Mr. Ala Mojumdar, that's a petitioner seeks for an adjournment to examine as to whether a review would be maintainable on the ground that after the judgment had been delivered, certain future events had taken place, and the future events may have led to a different order being passed by the court. List again.
49. After
49. Yes, sir. Where is the order violated, madam? 25. Your name? A. Hussain, 6 weeks notice.
50.
Where is the order violated? Page number 10.
In terms of the portal of the DO submit the portal.
Have you communicated the order? Which page? 16. No, where have you communicated? Where is the communication? Without communication, there is no contempt. I know. We have to go by the law. Unless you communicate the court's order, no contempt is maintainable. We have seen it. That something may have been processed. There are correspondences between different officials. We have seen that. But to bind them in a contempt, you'll have to serve the copy of the order. Otherwise, no contempt. Miscase. What kind of miscase will you find? But if you communicate it now, this petition will not be maintainable. There will be a future contempt after the communication. So we close this one. The petitioner to produce the communication that may have been made by the petitioner to the respondent containers serving a copy of the order which is alleged to have been violated. This form extended in the
51.
Instead of that, why don't you do it the other way around? You lose more time. We close this petition, give it a liberty to serve upon him. After 1 month, we come back with a content. It will be faster for you. You don't want, don't do it. What instruction? Contempt. No, it's a contempt case. It's a contempt case. Where is the order of the court which is violated? 27/4/2022. Annexure 8, page number. It appears that there is no contempt. That's why I'm asking you this question. Violence of the order dated 27/4/2022. Which page is that order? 33. Yes, who appears? Mr. Saikya. Give her a copy of the petition. Come to page 33.
33.
Para 9 directs the deputy commissioner, who is the chairman, to place the application for consider for appointment to any post which he is qualified for. possibly this order is violated.
Right.
You provide us the information, ask the deputy commissioner
Right.
whether any application of this writ petitioner, Mursida Yasmin Laskar was placed before the DLC.
Right.
Why do you issue contempt notice for this? We request Mr. P. Sakya, Learned Counsel, who otherwise would have appeared for the Deputy Commissioner Hailakandi to provide the information as to whether pursuant to the order dated 27/4/2022 in WPC 6383/2021, the application of the petitioner for compassionate appointment was placed before the DLC. Which the petitioner may be qualified as per educational qualification. List on why didn't you get it right now? Ask him over phone. Tell him that one contempt petition has been filed. Only direction is to place it before the DLC for any year, whether you have placed or not. If you have placed, tell us, we'll inform the petitioner. If you have not placed, place it. These kind of contempt petitions are not no requirement to issue any notice. Monday listing is difficult. Why don't we get it right now? We'll pass the order today only. It's a matter of record. All that you have to see is whether it was placed or it was not placed. That's all. It will save everybody a lot of time. If I issue notice, you'll give the same reply after 6 months. No, I have done this. And why should contempt notice be so casually issued? Give us the information. Try to find out. You have a copy with it. Just ask him whether this application was placed or not placed. Just next item.
52.
My lord, there is a direction to the CID to conduct an inquiry.
Who? Oh, in this matter.
My lord, CID officer, he has already taken, my lord, statement of 3-4 discharge, my lord. 3 discharge already transferred, my lord. And problem is that, my lord, that candidate, my lord, he is not.
Oh, that tearing of answer papers.
My lord.
Mr. P. Sakya, Learned Counsel, whom do you appear?
My lord, court has specially directed to.
Learned Counsel, Learned Counsel seeks for some further time to provide the report of the inquiry that may be made by the state CID in terms of the order dated 11/9/2023. List on when you want.
Yes, sir.
53 to 55 for hearing.
What is this matter? You want an adjournment? Adjourn on the prayer, Mr. N.K. Chaudhary, Learned Counsel petition. You want a fixed date? Not required. Sorry. Okay. List again.
22nd.
You have any urgency? No.
No, sir. Most of the petitioners are
Vice
regular. In 2017, item number.
You make a mention whenever you want. In this
Item 56 and 57 for motion.
Lordship, in this case, we have received the instruction, so my lord may grant sometime.
Mr. K. Gogoi, Learned for Higher Education.
Lordship.
Since the instruction received and the affidavit would be filed with him.
In a period of 2 weeks, Lordship.
3 weeks, wherever list on so and so.
Lordship may issue formal notice, Lordship. In the meantime, we'll file affidavit.
তার আগত তেতিয়া সব লিখে বিডি দা সিনিয়র কাউন্সিল হেৰি অমুক অমুক ইস্যু নোটিস ৰিটাৰ্ণেবল
4 weeks, Lordship.
4 weeks extra copies sorry same okay
Same, Lordship.
I need to remember 4 weeks extra copies 3 days any private respondent or all by Mr. Gogoi
College is there, Lordship.
Eri higher education department, finance department, baki kita respondent registered post 3 days. Returnable heri 4 weeks. It is stated by Mr. K. Gogoi, Land Council for the higher that the instruction is received and the affidavit will be filed before the next returnable date. List after 4 weeks. Interim order is there. Fixed it, list on so and so, interim order to continue till then.
50.
Interim order
to-
was passed after hearing or it was without hearing? After hearing. Then normally it should be until further orders.
No, Lordship says.
No, normally
Lordship is indicated status to as on today maintain.
in most of the cases I file until further orders. Why is it made till the next date then?
Lordship may,
There must be some reason.
there is a reason, Lordship. There are concurrent other part. There because government has created newly that science system.
Okay, next date.
Lordship.
Item 58 to 61.
Oblige, Lordship.
Senior counsel. Hey, at a date change. Item 37.
Yes. List is matron so and so along with WBC so and so. That's the only order.
Lordship. Order the Lordship may accommodate us. File is Mr. A.R. Tobila is in bereavement, Lordship. We are not able to,
Bereavement.
Lordship. So any other day, Lordship.
Adjourned on the inconvenience of Mr. E. Tobida, Land Council for the Higher Education Department, as paid by Mr. K. Gupta.
Lordship.
List on whenever you. When do you want?
Not then, Lordship, notice we have.
Only notice.
Notice then, Lordship.
Then why did he ask it to be listed alone? Maybe we are thinking of not issuing notice. Then why did he got it listed with other matters?
Last occasion petitioner says that they have prepared another repetition, so Lordship says directed to club all the repetition together.
Let it be on the next day. We'll hear you.
Lordship.
Suppose this is the second repetition on the same issue.
Lordship.
Possible.
Yes, I
Matok, next.
Item 62 for orders.
A fixed date. We'll hear you.
9th November.
What? Not happy with the
No,
date?
will done. Just no.
Mhm.
Just no.
Correction of typographical mistake.
Page number,
Page 8, my lord.
page
Page number 8.
8.
Para 2, my lord. Second line. Dakshin Bahunasam LP School in Kalchar, my lord. Instead of Kalchar, my lord, it should be Karimganj.
Karimganj. That's the only mistake. Third MS is very good. This application is issued for correcting the paragraph 2 of the order dated 25/9/2023 in WBC 4899/2023, wherein it is provided that the father of the petitioner, Vijit Kanto Das, was an assistant teacher in 1317 number Dokhin Brahmanashan LP School in the Kachar district. It is stated that the correct depiction ought to have been 131 Dokhin Brahmanashan in the Karimganj district. Correction accordingly allowed. Para 2 be now read to be 131 Dokhin LP School in the Karimganj district.
64.
Correction, which page? Page number. Page number.
Page, is page 7. The authority respondent, the appointment on the date of the.
Mr. Borua, which word to be
Yes,
corrected?
Page 8, last line.
Actually,
Page
your lordship has raised 2023, actually 2018, my lord.
38, 2018.
18, my lord, after
Yeah.
5 years, that they have not enclosed the order, my lord.
Let it be. We correct it.
Because after 5 years, they have come, my lord.
No, no. He wants a correction of an order.
I understand.
So we correct it.
Yes.
Read petition, we don't know. You oppose it.
But there is a stay order, that's why, my lord.
No. In view of the
2018.
correction, you file your application for vacating.
Yeah, I will find.
We'll vacate it.
Yes. Because 2018,
Uh,
after 5 years, they have come, my lord, your lordship. I
Mr.
can-
Kotogi, we understand. On a wrong recording of a date, interim order passed.
Yes.
Now, after correction, you have a right to file an
Yes.
application to vacate the interim
Yes,
order.
yes.
PP Borwal and counsel for the applicant, Mr. P. Kotoki for Assam Agriculture University. And Mr. K. Gogoi for the Higher Education Department. By this application, the order dated 6/10/2023 in respect of para 7 is sought to be corrected that the order depicted therein ought to be order dated 38/2018 and not 38/2023. Correction allowed.
And 11.
The date as appears in para 7 and para 11 be now read to be order dated 38/2018 and not 38. Mr. P. Kotoki says that in view of the correction of date, the prima facie case made out by the petitioner may not exist any further. If it is so, respondents may file application for modification of the interim order. I allowed as indicated.
65 and 66.
65, 66. Yes, Mr. Sharma.
The relevant matter you want to say that I sent the direction for the committee board on 38.
66 to so.
It's the relevant time.
We take up the IA today.
Yes.
IA for
I-
implement of
The HOD, the physiology department, all the,
what's the name? The only the HOD.
Bhagwan Bhavan, your lordship was not directed the page 18 and 19.
No, we implemented.
Yes, yes.
Heard Mr. M. Sharma, like, also heard Mr. P. Kotogi, Land Council of Agriculture Department, and Mr. Where is Mr. Gogoi gone? K. Gogoi. Where is? Oh, you are there for the Higher Education Department. By this interlocutory application, the HOD of which department? It's Dr. Bhagavan Bhorali. Is sought to be implemented as respondent number 5 in WPC 4996/2023. No objection to the prayer for implement is from the side of respondent. According the Sri Dr. Bhagavan Bhorali is implemented as respondent number 5 in WSO, and so registry to incorporate necessary correction and also correct the CIS system. I allowed as indicated, main repeater likhbo, issue notice for registered post and respondent number 5 within 3 days.
Time being item 4.
What was this?
Got my instruction. Already there's this thing pending.
No, this is quick word. Don't do it. Don't do that. Don't do it. Better to go to 6 weeks.
What is this? Reference causally stated so and so. I'd like to say that the case is listed. What is today's date?
Lordship, this was sent, this was given to us.
7 September.
Yes, Lord.
Why do you need 7? We wanted the information whether what is the name of the album, some Akhir or something. Whether Akhir Ali had filed any writ petition
Yes,
and what?
it's on the last page. Your lordship takes the last page. There is already a writ petition filed there. Bearing 4, 5, I have given the whole thing. Lordship comes to the last page, the second last page, third last page. WPC 4564 of.
List
23.
along with WBC 4564/2020.
There already a case is pending and my lord.
List along with the same one or
Something is fishy, that's why they have not given this one.
Not fishy, my lord. Your lordship.
Mr. No one is,
So that
I
is why.
think
they-
everybody had your lunch.
If I say one time.
Mr. Fukan, I think everybody had your lunch. Fish is not relevant anymore.
My lord.
We'll list it together, we'll hear you together.
Can I date be fixed?
Yes.
WBC number 2.
WBC 4564 of this 20.
23 months.
Well, it will come for Muson, my lord.
Yes.
It is a Muson matter.
Ah. Motion matter along with the other petition.
17 November.
Keep your.
Item 9.
Yes, madam, what is this?
Their lordship. Minor. Not permanent.
Adim. Something more.
There is an order. That means the minor. Telling me that order. Thereafter, what we can see variable 41. During the pendency of the writ petition, the case was forwarded by the 41. 41. 30.
So ultimately, what is your grievance now? Which petition?
Pending earlier. Page number 42 onwards, 43 is the relevant.
42, WBC 11692. Oh,
That was dismissed.
let it be dismissed. Now, how you are affected? Why are you before the court now?
Passing that order, saying that I was minor. Case was taken, forwarded, case before TLC. Both the case of, both that impute are challenging that impute order execution of.
Madam, come straight to the point. What is your grievance now?
My case again. They open a-
Why? Again, why? No, why again? You cannot direct to repeatedly place the application before the DLC. Either you challenge the earlier DLC saying it to be illegal, we'll send it back.
That order is challenged that petition. But this is later on. After forwarding of the our case again.
No, you have not understood anything. That's a difficulty. I have not understood the matters.
Page number 39 order was challenged.
First, you tell us what had happened. Start from the beginning. The father died. On which date you are adding words, that's a difficulty. On which date you filed application? Because by adding word, Madam Kanungo, you are going elsewhere, which is making it difficult for us to understand. What happened with that application?
That application was not placed before TLC.
You came to the court. There was a direction to place or no direction to place?
There was direction placed.
Place, okay. What happened when it was rejected? After, against the rejection order, what did you do?
Rejection order was made
Uh,
during after this rejection, during the pendency of that writ petition, my case was again.
Again
forwarded.
placed,
Yes.
again forwarded or placed? Forwarded or placed? That will not give any right. They are not required to forward it after rejection.
Case before next case.
After rejection, there cannot be repeated placing. How can we say? Maybe 41. So now what do you order? Or you want to compliance of this order? Why?
Appointed case order.
Compassion doesn't mean it will go without following the law. Where is the rejection?
39.
39.
Saying that I was minor at the time of death of the father.
So we set aside that one.
That was already. That was not in filed. Another writ petition challenging this order during the pendency of the writ petition, this forwarding was done. And
Ultimately, that petition, what happened?
was rejected.
Where is the rejection order?
It is a long order worship, lastly, page number 47, 48 is a related.
Yes, Mr. Pico, what do you say?
In this order, my lord, that opinion is different, my lord. Otherwise, this type of cases, my lord, your order is before, you know. But it was minor at the time of death of the. my lord.
Only thing your additional deputy commissioner has opened the door once again.
Man.
My lord's order.
That will not help you. Once case is rejected, see, have your petition been before another court? It would have allowed, in other court it is got dismissed. How can you again come back to the other court, say, no, we passed that order? I told you in the morning, we are not here to provide fortune to the people. We are here to only decide law. Word unfortunate will not. Yes, Mr. Pegu, can you think of a way out for this?
Rejection, my lord, after that letter from the ADC, my lord.
So yes, you have you yourself opened out. Process it.
With compassion, my lord, it can be done.
Had the MSS counsel for the petitioner also had. The father of the petitioner. Fakhruddin Loskor was an assistant teacher in the 147 number of Bayer Par Mokhtar LP school in the Hailakandi district, died in harness on 24/5/2006, and on his death, the petitioner made an application for compassionate appointment on 2012. It is stated that at the time of the death, the petition was a minor, and subsequently upon attaining majority, the application was made. The said application was placed before the DLC of Hailakandi district in its meeting of 5/10/2021, and the DLC. Why was it rejected? By DLC by providing the reason that at the time of death, the petitioner or minor had rejected the application. Being aggrieved, WPC 1692/2022 was instituted, which was given a final consideration by the order dated 9/2/2023, whereby the writ petition filed by the petitioner was rejected. From such point of view, no further consideration is required in this writ petition. But however, we notice that the additional deputy commissioner, Hailakandi, where is it?
Page 41.
By the communication dated 19/1/2023, had required the district elementary education officer to again place the application of petitioner before they again placed before the concerned DLC. It is noticed that the said communication is dated 19/1/2023, whereas the earlier dismissal of WPC, dismissal of the earlier WPC 1692/2022 is dated 9/2/2023, which is subsequent. Without expressing any view on the order dated 9/2/2023, as the Deputy Commissioner had additional Deputy Commissioner had required the application of petitioner to be again placed before the DLC. We direct the respondents to complete the process and place it again. In doing so, as the petitioner was a minor at the time of death, the law laid down by the Supreme Court in Khadim be taken note of by the DLC.
Time being item 10.
Petitioner to provide a petition to the SSA. Who appears for SSA? Yes, Mr. Sharma, what is your matter? Mr. Sharma, please start. Reconsider the cabinet decision based on petitions have been released. Pending disposal, please to grant. If you read in the item. So your interim order and final order, final prayer both are same. We issue notice. Heard Mr. R.P. Sharma, the council of petitioner, also heard. No, but there is no prayer. Also heard. Who is there? No one is there. Elementary education, Mr. B. Kaushik for the Elementary Education Department. SSA. And Mr. P. Saikia for. No, you were not there.
SSA B Chaudhary name can be.
Where is he?
We'll inform them. He was there today morning. Today.
Appearance cannot be in absence. Both word has two conflicting meaning. Appearance means present, absence means not present.
Right.
If he comes, we'll record this day. For notice 6 weeks, extra copies 3 days. Subject to the result. Joining of who? The respondents.
Yes, we have joined.
The petitioners have joined.
Where do you have joined? Then if you have joined, why are you filing a petition?
Because that was the produce matter. The order of our replacement was illegal. That is what.
No. What interim order should I pass? The joining of the petitioners, as stated, shall be subject to the result of the petition.
43.
Mr. Chaudhary, at the time of signing, we went through, we had a feeling that this is a case which does not call for absolute rejection of the interim order, nor it calls for a complete interim order. Better hear it. Because both ways it will be an extreme order.
Only thing is, my lord,
We have taken note of everything.
two of our selected, I mean, the DPC selected candidate, my lord, they are retiring in this.
So ultimately, the earlier proposal, let the authorities take a call. I think that will serve the purpose.
Make on submission, my lord. Since petitioner is only one, the stay order has come in the way of promotion of.
No, but the issue he raises,
No, my lord.
let one post be kept vacant.
Understand?
And
Normally,
the promotion
no,
will be made subject to the.
no,
outcome.
normally, yes.
Yes.
But the issue he has raised
Yes.
will be allowing people without jurisdiction to hold the post.
No, my lord.
That will be against
That
it.
their case is absolutely misconceived.
So let us hear it. That's why I say, on which date you want?
On
Today?
Tuesday.
Today also we are ready.
Tuesday, my lord.
Tuesday.
But today he can start, I'll give my reply on Tuesday.
I think better take a call.
Ah.
Because otherwise what happens,
Yes.
both ways, it
I
will be little.
I followed.
Okay, you start.
Tuesday.
Tuesday again, we don't know. Tuesday is very difficult because that's the last day almost. Hmm. And we have to dictate order also. We need some time.
Otherwise also.
Mr. Das, we need some time to dictate and correct and because only hearing is, for you it is the end, but for me it is the beginning.
Correct.
But otherwise, also subject to what my senior says, there is one respondent who is retiring in October, others have 1.5 year or 2 years service. That is one aspect. Next is that, already the state has filed the affidavit in this matter. So instead of, considering the interim prayer, what we can finally hear the entire matter and finish it off.
That is what I intend to do. That's why I have to start
My
the
lord, my
hearing.
learned friend will have to satisfy that the NCT.
Or Mr.
That it applies,
Mr. Kaushik,
yes.
suppose we pass an interim order allowing the person retiring
Ah.
to take the post
Ah,
and make his appointment subject to the result.
yes,
Suppose ultimately dismissed, his will be regularized, he will retire as a principal. Rest, don't appoint for the time being. We'll list it immediately on the reopening and trash it out.
In fact,
Only thing, the person retiring, we have a little
Yes.
feeling for him.
yes,
Suppose the petition is dismissed, the man will miss out. So let us protect him,
my lord.
one man.
in fact, government on its own, page 151, that person, he was also retiring on July. So among the recommended one, to one we have promoted.
So let us do the same to the other one also.
Yes,
Yes.
I heard Mr. H.K. Das and also Mr. K. Chaudhary learn correspondence about a private bota, number get a silo. Mr. B. Kaushik for the your secondary elementary education department. And anybody else, Mr. Das? Anybody else?
7.
Private respondent, Mr. Kaushik, and anybody else?
I appear for the, my lord, right?
6 to 14.
I have applied for
Uh,
SCR.
where is he?
P I have for 2 and 3 members.
Where is he? Frankly speaking, Mr. Das, I find it difficult to write heard. In the absence of the learned counsel, I find it difficult to use the expression heard. It's not proper. Although convenience, yes, but court should not write a blatantly incorrect thing.
It's a judicial proceeding.
Hmm. So if you can show the face of, then also I can put it in. Itu thakok, যদি আহে যদি হেৰিটো। The notice, issue notice returnable on immediately opening fixed date. On so and so.
7 November.
Extra copies, say, extra copies for everybody, all the private respondent, Mr. Das.
Yes.
Hmm?
My senior is representing.
No, only one copy or number of respondents he is representing. Extra copies within 3 days.
Yes.
The selection of the respondents hearing as principal of the diets is assailed by the petitioner on the ground that on a conjoint reading of the rules in force, the rules of date to deliver, agor order to Rase lekha detail, and the NCET regulations of 2004. NCT regulations of 2014, there would be a requirement of the qualification of PhD in order to be selected and appointed as principal. But in the instant case, the respondents do not have the qualification of, respondents don't have the qualification of PhD. Mr. Kian Chaudhary, Learned Senior Counsel, representing the respond. Please don't disturb in the middle. Do you get any fun out of it when we express a few words? Then you take over, dictate, we'll sign it. Take over here, Why do you think so much? We're not required. I always say if there is any mistake, point out at the end of the order. We'll never say we are not going to correct it. It disturbs the entire thinking, you know. It's very difficult to come back, what I was originally thinking. For you, it's one word, for you, it's a second word, sorry, but for us, the whole thing is gone. I have to restructure the entire word once again. That's why it's a only request I make. Don't utter a word in the middle. We are always there with you to correct it if anything is required. Now read the whole thing once again, because I find it difficult.
Qualification of PhD.
Because the whole thing goes out in a flow. Now, once that flow is obstructed,
I follow.
it's very difficult to pick up again. People who
On the ground that using of the rules for flow and sensitive regulation 2014, there would be a requirement of the qualification of PhD in order to be selected and appointed as principal. But in the instant case, the respondents do not have the qualification of PhD.
Mr. Ken Chaudhary, Learned Senior Counsel for the private respondents, on the other hand, raises the contention. What do we record?
That NCT regulation which petitioner is relying, it applies to BA, not to us.
That the NCT regulation that the writ petitioner is relying upon is applicable only to those institutes where the BEd
is being
course is being undertaken, whereas in the institutes where the petitioners are respondents are appointed as respondents, the BEd course is
They are imparting DLED. right?
they are imparting
Diploma
the DLED course and not BEd. The aforesaid question issue requires a determination. But however, it is stated that the respondent number
6.
6, namely so and so, would be retiring from service on
31st.
31/10/2023. And therefore, in the event the determination is against the writ petitioner and in the interim the said respondent is not allowed to take over as the principal on being selected, he would suffer an irreparable loss which cannot be substituted later on. And consequently, the balance of convenience is in favor of respondent number so and so for an interim order. Accordingly, in the interim, it is provided that the respondent server may be allowed to join as the principal of
Or the DPC recommendation may be given effect.
or the recommendation of DPC selecting the respondent may be given effect. Effect forthwith, and the joining of the respondent number 4 as the phrase shall, but however shall be subject to the result of the writ petition.
Respondent number 6.
6, meaning thereby that in the event the writ petition is dismissed, the joining of the respondent would be constituted to be a regular joining on the post.
As principal.
And if otherwise, and on the writ petition being allowed, appropriate order shall be followed. In respect of the other respondents, the joining may be deferred till the next date of hearing, list on so and so.
7 November.
In the meantime, the respondents may file their affidavits if so advised. And if any affidavit is filed, the petitioner may also give the reply. It shall not join.
It has been modified only to the extent of respondent number 6. Board has indicated.
Earlier order was not to fill up the post without.
Earlier order, forget.
PhD and BA.
There is no earlier order. Earlier order is list again today.
Possibly, Your Lordship,
That was a view taken, but we thought that it requires some more hearing, that's all.
Possibly instead of joining, your lordship will say not to fill. Yes, because that is what.
Not to fill up.
Not to fill up, because promotion order has not been issued.
Okay, not to
Not
fill
to
up.
fill up.
Deep level.
So all are protected for the time being and we'll hear. And affidavit you filed, Mr. Kaushik.
We have
I
filed.
think state
It has filed affidavit.
already filed.
And that petitioner has decided. SCRT has not filed, but the respondent number.
But where is SCRT?
Yeah, not yet.
Ask him to come.
State affidavit will, of course, will be enough for that, because
So ask him to come because diets are under the SCRT. They know. Oh,
Hey, what is the answer? What no, no.
Mr. Jalia, you appear for SCRT? Usually for SCRT. Before the next returnable date, the responding SCRT to also file their affidavit because your affidavit will be most vital
yes,
because you are the department.
regarding the courses they offer.
If any affidavits are filed by respondent, the affidavits to be filed by respondents be completed 1 week prior to the next returnable date. And the writ petitioners, if advised, may file their reply. So that the matter would be ready for hearing on the next returnable date.
Declare. One clarification. Nothing on merit. On 31/7/2023, notice was already issued in this matter. That's what I wanted to. I did not
The
want to
notice is
interrupt.
already issued.
Yes,
তেতিয়া issue notice to nalage baki khini thakok.
yes. I did not interrupt.
I understand. No, otherwise,
I understand it.
I don't know about others. My way of functioning is,
Follow that, my lord.
No,
Towards the end, we normally say.
no, my way of functioning is, the whole thing is conceived in the mind and,
Go get
Hmm.
subscribed.
no, that what to be dictated is conceived first. And then you start dictating. Once you interrupt that, what is conceived goes out.
Deep level.
I don't know. Item 51.
I will say. 51 contempt.
Case of the petition is placed before the DLC.
Huh?
Case of the petition is placed before the DLC,
Was placed
my lord.
after this.
My lord,
Then where is the order?
I got order not passed, it is minor change under preparation. my lord.
Sorry.
Minor change under preparation. my
But it is placed.
Placed.
District petition is instituted alleging willful and deliberate violation of the order dated 27/4/2022 in WBC 6383/2021, wherein as per paragraph 9, there is a direction to the Deputy Commissioner Hailakandi to place the application petitioner for consideration for appointment on compassionate ground to any post to which the petitioner is qualified as per her qualification. Considering the nature of the direction issued, we require Mr. P. Saikia, Learned Counsel, who appears for the Deputy Commissioner Hailakandi, to provide the information as to whether the application was placed or it was not placed. The information provided is that the application was placed before the DLC in its meeting of, we put that date, huh?
My lord.
But however, the minutes of the meeting are yet to be prepared. In view of such statement, contempt petition in the present form is not maintainable, closed. But however, if the petitioner is agreed by any decision of the DLC, liberty remains to approach again. Every matter, we should not issue a contempt notice. It's a burden on everyone. Only thing, of course, you will be not be knowing. Arvase?